Honorable Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez.
Welcome to the first day of our fall 2025 oral argument session here in Philadelphia. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May 2022, we celebrated the court's 300th anniversary here in Philadelphia. We on the court are very proud of our rich history. In its earliest years, our court actually room in the State House, now Independence Hall. Beginning construction in 1871, it took 30 years to construct this City Hall. It was designed in the French Second Empire style by John MacArthur Jr. and Thomas Ustick Walter. Sitting atop the building is a bronze statue of William Penn, standing 37 feet tall and weighing 27 tons. Mr. Penn's statue faces northeast and points to a spot where he signed This court became the first tenant in this building on January 1st, 1877. After the official opening, reporters deemed this to be the most handsome courtroom in the country and concluded that some of the more fastidious lawyers will hereinafter take only Supreme Court cases in order that they may practice in this court palace. I hope that this courtroom's history is inspirational to all of you. I would like to introduce some students who are here with us today. They are from Temple University, Beasley School of Law, and they're here with their professor, Marian Braccia. Professor Braccia and your students, would you stand so that we can welcome you? Thank you for being here. We hope that you learned something today, students, and a cautionary word of advice to the lawyers: try not to dissuade these students from pursuing a career in law today. Appellants counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel to the court and identifying the party you represent. The justices are familiar with your cases, so we ask that you would avoid any unnecessary recitation of the facts or procedural history, and instead try to focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question, although we may interrupt you. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we wish to explore further. I remind you that in this court we do not permit rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. Appellees Shannon and Keith Chilutti filed a lawsuit against Uber Technologies, Inc. and its subsidiaries, seeking damages for injuries that Shannon incurred while riding as a passenger in a motor vehicle she hired using Uber's rideshare app. In response to the lawsuit, Uber filed a petition to compel arbitration, alleging that pursuant to the terms and conditions of the Uber app, to which appellees agreed when signing up to use the app, all claims related to the use of the app must be submitted to binding arbitration. The trial court granted Uber's petition to compel arbitration and stayed appellee's lawsuit. Appellees subsequently appealed to the Superior Court, which is a threshold matter, determined that the trial court's order was a collateral order under Rule 313 of the Pennsylvania Rules of Appellate Procedure, and thus was immediately appealable. On the merits of their claims, the court concluded that the trial court erred in compelling appellees to submit to arbitration, finding that there was no agreement to arbitrate between the parties because Uber's website did not include a conspicuous notice to alert users that they were waiving their constitutional right to a jury trial. From the court's perspective, this rendered appellee's waiver of the right to a jury trial unknowing and involuntary. We granted allowance of appeal to determine whether an order compelling arbitration is immediately appealable under Rule 313. As well, we consider whether the Superior Court's notice requirement for arbitration agreements runs afoul of the public policy favoring arbitration. Good morning.
Good morning. Thank you, Madam Chief Justice. May it please the Court. Michael Kickline on behalf of the Uber appellants, and I'm here with my colleague this morning, Matthew Clayman. The Superior Court's decision and the Chilutti's position on appeal rests on...
Could you move the microphone closer to you? Thank you.
Apologies.
Thank you.
The Superior Court's decision and the Chilutti's position on appeal rests on several erroneous departures from settled law. This appeal should have never proceeded because the Superior Court lacked jurisdiction. The trial court's order is neither a final order nor a collateral order. And even if the Superior Court had jurisdiction, the Superior Court's newly invented stricter burden of proof for demonstrating assent to arbitration agreements violates the Federal Arbitration Act and Supreme Court precedent by singling out arbitration agreements for disfavored treatment based on rules that are not applicable to contracts generally.
Well, no one's claiming it's a final order, right? The question is it a collateral order?
Well, that's correct, Your Honor. The principal argument here is that it is a collateral order under Rule 313. And finally, applying objective standards to the question of contract formation, the Chiluttis were provided reasonably conspicuous notice of the terms of their agreements, and they objectively manifested their assent by taking affirmative action. And they're bound by those agreements. For those reasons, we believe the Superior Court's decision should be vacated or reversed. Now, the Superior Court lacked jurisdiction to hear this appeal because, as I said, an order staying litigation pending arbitration is not final, and this is confirmed by the Uniform Arbitration Act, which does not permit an immediate appeal of an order staying litigation and ordering the parties to proceed in arbitration. And that was the crux of the Molesky holding more than 30 years ago, where this court found that there was no express statutory authority authorizing an appeal of a court order staying litigation pending arbitration. But as the Chief Justice pointed out, the question here is whether Rule 313 applies and whether the trial court's order satisfies the requirements of Rule 313. As this court well knows, Rule 313 is an exception to the final order rule that must be stringently and narrowly applied in order to avoid what the court has referred to as undue corrosion of the final order rule and to prevent the delay occasioned by piecemeal appeals of trial court orders. Here, the Chiluttis cannot establish the irreparable loss requirement under Rule 313, and that's really the key issue here. They cannot demonstrate that the question presented, namely whether they entered into an arbitration agreement with Uber, will be unreviewable if they have to await final judgment review. They will not suffer any irreparable loss as this court has defined it. Now, the Chiluttis will not lose their right to final review. They may appeal the trial court's order after arbitration and upon return to the trial court, where there will be confirmation proceedings and post-arbitration proceedings, and final judgment will be entered. The Chiluttis do not cite any authority holding that once they proceed to arbitration, their right to appellate review of the question I just articulated, that is, whether an agreement was formed, will be irrevocably extinguished.
To be clear, though, it's a very narrow standard scope of review if they seek appellate review after an arbitration.
Well, Your Honor, the standard of review I think you're referring to is the standard that comes from Section 7341 of the Uniform Arbitration Act. And that was the basis of the Superior Court's ruling, sole basis, that the irreparable loss requirement was met here. Now, Section 7341 provides that an award of an arbitrator may not be vacated or modified unless it is clearly shown that a party was denied a hearing or that fraud, misconduct, corruption, or other irregularity caused the rendition of an unjust, inequitable, or unconscionable award. And having concluded that 7341 applies, the Superior Court then reasoned that the question presented here would not satisfy the requirement that there be some malfeasance as defined in 7341. And the Superior Court went on to find that even if the parties didn't agree to arbitration, there's always the possibility that a court may find a subsequent arbitration fair and thus remain binding on the parties. And that was the crux of the ruling for why the court concluded there was an irreparable loss of a right here or that the matter would be effectively unreviewable. But Section 7341 would not govern a post-arbitration appeal by the Chiluttis on the question they're presenting here. On its face, 7341 applies where a party seeks to vacate an arbitration award based on arbitrator malfeasance or irregularity in the arbitration process itself. It does not apply to an appeal challenging the trial court's order directing the parties to arbitration in the first place. So 7341 goes to the arbitrator conduct, the arbitration process, and the basis upon which you might seek to vacate an award. That does not apply here where the parties, well, the Chiluttis would seek to appeal the trial court's order directing them to arbitration in the first place.
The point being that it's jurisdictional. It would be a jurisdictional challenge and therefore not a narrow standard.
Correct. That standard just does, 7341 just does not apply, and the appeal of the trial court's original order would be outside the scope of 7341.
Well, because that's not the standard of review the Superior Court applied below here. They didn't apply the deferential arbitration standard. Whatever standard they applied below would be the same standard that they would apply eventually when it came up at the end of the arbitration.
Well, they wouldn't apply any standards under 7341.
No, right.
Right,
So I'm
right.
saying, but
Yeah,
they didn't
it would
apply
be
them here.
That's
They would-
correct.
It'd be the same procedural posture as they exercised here. It'd be the same standard of review. It wouldn't be deferential arbitration. It'd be de novo.
That's correct, Your Honor. That is correct. So in a post-arbitration, post-final judgment posture, the Superior Court may review the trial court's order if it determines that the parties did not enter into a valid arbitration agreement, and the court can, on review, remand the matter for a trial. And that's exactly what has been happening in the Superior Court. If you look at cases like Sivon and Del Cioto, and most recently the Carr decision, in all of those cases, parties like the Chiluttis who were objecting to arbitration on the grounds of lack of an agreement to go there, they obtained appellate review on that precise question in each of those three cases. So the law has been permitting this type of an appeal post-arbitration for some time. Now, yes?
Focusing on the standards set forth in Rule 313, why is it that a order denying arbitration
found, based on the cost and the burden of having to litigate to final judgment after arbitration, their argument is that's a sufficient loss to trigger a finding of irreparable loss under 313. But as this court well knows, historically irreparable loss has been found in those settings where you can't unring the bell, right? So, for example, this court has found that the irreparable loss requirement is met in cases involving privilege or the right to confidentiality of information. Once disclosed, once you move past that, you can't unring the bell. Matters involving sovereign immunity, right, where forcing the defendant to proceed to final judgment would negate the very purpose of the defense to be absolutely free from suit. And there are numerous other instances, but what they all indicate is that there must be a clear and irreparable loss of judgment is not sufficient. In fact, in the JCD decision, this court held that an order granting grandparents standing to seek pretrial custody of their children was not a collateral order. The court found that the parents could appeal that if there was an award of custody eventually, even though, as the court recognized, the parents would be forced to litigate to conclusion and endure the heavy cost burdens and emotional energy attendant to custody litigation. But that burden and that cost was not enough, and as Justice Wecht observed in concurrence in the JCD decision, the expenditure of time, money, and energy is present in every case. You could find that in just about any situation. And, as the Justice noted, if the expenditure alone were sufficient to satisfy Rule 313, then every interlocutory order presumably would satisfy the irreparable loss prong, and the exception would devour the rule. Now, the Chiluttis base this argument primarily on the Pridgeon versus Parker-Hannafin case. Pridgeon involved the statute of repose in the Federal General Aviation Revitalization Act in 1994, which sought to immunize aviation manufacturers from the cost of litigation. And there, the federal courts had interpreted the statute as creating an explicit statutory right not to stand trial after the statute of repose. So Pridgeon is akin to an immunity case, and while this court did in that case find that substantial litigation cost would suffice for purposes, in that case, of Rule 313, as Justice Wecht noted in JCD, that decision was uniquely grounded in a strong and clear federal policy of containing costs in the public interest. Similar to the immunity situation where the protection from cost is part of protecting the public fisc. But there's no such policy implicated here, and Pridgeon certainly doesn't stand for a general rule that substantial cost of litigating to final judgment is sufficient for purposes of Rule 313. And finally, on this point, I would note that the policy stakes here weigh heavily against allowing an immediate appeal of every trial court order staying litigation pending arbitration. Arbitration is supposed to be efficient, and that's why both Pennsylvania and federal policy strongly favor arbitration, and allowing immediate appeals every time there's an order compelling arbitration and staying the litigation would be contrary, really, to that policy. And there is a policy choice reflected here, as I said earlier, in the Uniform Arbitration Act, which specifically allows an appeal of an order denying a petition to compel arbitration, but makes no provision for appealing orders such as the one at issue here. So I think on the jurisdictional question, it's plain that the Chiluttis will suffer no irreparable loss as defined by this court, and the question of whether they entered into an arbitration agreement will not be rendered unreviewable, and that's the test that we believe has not been met here, and therefore supports the conclusion that the Superior Court erred in finding that there was collateral order jurisdiction.
Are there any questions from the justices? Thank you, Mr. Tischling. We'll hear from Mr. Mesa.
I'm sorry, Your I was going to address the preemption argument as well as the,
Oh, that sounded like a conclusion.
a conclusion on the first argument on jurisdiction.
I thought you were so confident that you were going to get it quashed that you weren't moving on.
Well, I am confident, but
My mistake. Sorry, please, go ahead with issue 2.
sure. Because the court lacked jurisdiction, this court need not reach the merits question. But if it does, the court should reverse the Superior Court's decision because its newly invented rule imposing a stricter burden of proof for establishing assent to an arbitration agreement is preempted by the Federal Arbitration Act. Section 2 of the FAA, I'll refer to that as the FAA, provides that arbitration agreements must be enforced, quote, save upon such grounds as exist at law or in equity for the revocation of any contract. And that's really the critical language, of any contract. And what that means is a court may not single out arbitration provisions for suspect status and disfavored treatment and must place them on equal footing with all other contracts. Now, the Superior Court's decision does just the opposite. By its own admission, the Superior Court created the stricter burden of proof to apply to arbitration agreements and only arbitration agreements, and it did so out of concern for the right of protecting the jury trial right. But the stricter burden of proof that has been articulated requires that these registration websites and application screens must explicitly notify a consumer that they're waiving their jury trial right if they agree to Uber's terms. The court also is now requiring that the registration process cannot be completed until the consumer is fully informed of that waiver.
Counsel, what's the harm in that?
What's the harm? The harm in that is that it violates the Federal Arbitration Act because it singles out arbitration for special notice requirements that are not applicable to other contracts. So based on the language of Section 2 of the FAA and the longstanding Supreme Court authority interpreting it, that the harm in that is that it violates and offends the...
Why, how is that possible if other businesses can use these hyperlinks as well? The issue is not isolating an arbitration. The issue is, if we get to it, proper notice that you're waiving your right to a jury trial or a trial.
Well,
What's the harm in that?
what's the harm in requiring the special notices that
So
were...
instead of going down 6 pages to terms and conditions and saying you have to check it all for somehow adding all kind of restrictions, what is the harm by saying, you know, at some point you had to acknowledge reading and receipt of that notice?
Well, Justice Doherty, I don't know that there's harm in it, in doing that. Our argument is that a requirement that we do that violates the FAA. I mean, if you...
And share with us in particular, what part of the FAA does it violate?
Well, it violates Section 2, right, which says that the only grounds upon which you can refuse to enforce an arbitration agreement or invalidate an arbitration agreement must be a basis that's applicable to any contract, all contracts. Can't just be applicable specifically to arbitration agreements. It has to be a rule that applies to all contracts. Purchase and sale agreements, leases, you name it.
So we write the laws to be any use of a hyperlink that affects not just arbitration, any business that would like to engage in a contract through hyperlinks.
Well, I think the use of hyperlinks is obviously quite prevalent, and there's nothing impermissible about them, and one can use them. And that's what was done here. They were given reasonably conspicuous notice of those hyperlinks. The hyperlinks take you to the terms, and the terms are all there to be read, to be understood, to do whatever you want with them.
That's generous. I guess I'm trying to figure out this, assuming we get to the merits, this inflection of the constitutional right to a jury trial, which I understand is more of a contract between the government and the people. the government not being able to deprive you of your right to a jury trial. Why isn't this, why is that the focus, and why isn't it just a matter of a meeting of the minds, contract principles? To your point, if the Superior Court just applied a basic meeting of the minds standard, 4 corners of the document, was there mutual assent to arbitration? Isn't that the proper paradigm that there should be looking through this? And then you can say, or make an argument without violating the Federal Arbitration Act, that there was no, that given the nature of this hyperlink and the absence of some sort of an assurance that there was a reading of it, that there was no meeting of the minds, therefore there was no contract. Why isn't that the better paradigm than talking about some hyper right to a jury trial under the Pennsylvania Constitution when there's no government entity involved here?
Well, Your Honor, the test, and the test that we urge this court to adopt if you were to get to the merits, is a test that's based on objective standards of contract. So that... Which
is the test I'm suggesting.
Yes.
Which is
yeah.
What's your best argument that there was an actual meeting of the minds in this case to arbitrate?
Well, meeting of the minds is an interesting term because the way it's been used in this case, it could sort of imply that there has to be some knowing, voluntary, conscious understanding. But that's not what objective principles of contract law require. Under the objective principles, which this court has espoused and held in numerous cases, you look to the parties' objective manifestations of assent, so that even if there's a lack of actual knowledge of what the terms of the agreement call for, under the objective principles, looking at the objective indicators, as many courts have done, and we've cited those cases, you look to whether the parties were on notice that terms were being offered, that they were provided an opportunity to review those terms, and that they objectively manifested their assent to those terms by, in this case, clicking a button that says, by clicking the button, you agree to the terms and conditions, or by clicking an arrow. So the objective standard, we think, is the right standard that the court should apply if the court were to reach the merits of the question.
I have a factual question on that premise. Do you, or was there uncovered during the course of whatever discovery was done in the case, able to tell the court of the number of Uber subscribers, how many actually clicked the hyperlink?
Your Honor, that, to my knowledge, is not in the record evidence in this case. I don't know. I'm not in a position to give the court an answer to that question. But I suspect there are quite a number that do not review the terms. I think that's, something that we can all recognize. I mean, people don't do it.
But under your argument, it doesn't matter.
Under our argument, it doesn't matter because the test should be, were they aware that terms were being presented? Were those terms available to them? And did they manifest assent? It's really completely aligned with the longstanding contract law of the Commonwealth, where the court has never asked whether a party to a contract read it, understood it, nothing of the sort. In fact, the cases go the other way to say, if you don't read the contract, then that's your prerogative. But
that's Taylor versus Extendicare, right? I mean, the only difference, I think, there is that was not about, that was not an online arbitration provision. That was a
think leads to the conclusion I was discussing previously, which is what the Superior Court did here is to create special rules, special notice rules are consistent with what the Superior Court did. So for example, when the Superior Court says you have to tell the person up front on the registration website that by agreeing to the terms you're waiving a jury trial, there is no generally applicable contract principle that requires disclosure of the consequences of entering into an agreement. That's not a principle broadly applicable to all contracts. Or when the Superior Court says, well, this provision has to be at the top of the page and provided in all bold, italicized words. There is no general principle that applies such a requirement to all contracts. And that's where this runs afoul of the FAA. It is arbitration specific, and it's not consistent with generally applicable contract rules or defenses. So there, Montana had adopted a law that said in the arbitration setting, you have to put at the top of the contract that the contract's subject to arbitration. And an 8-to-1 decision, Justice Ginsburg struck that down. You cannot require special notice for an agreement because it's an arbitration agreement or that it waives the jury trial right. Similarly, in the Kindred case, same argument, right? There, the Kentucky Supreme Court had adopted what it called a clear statement rule, that before an attorney in fact could bind his or her principal to an arbitration agreement, there had to be a clear statement. They had to expressly authorize that action. And the court struck that down again in an 8-to-1 decision on the basis that when you adopt a rule that, as Justice Kagan said, the rule is hinged on the very fact that the arbitration agreement waives a jury trial, that violates the law in FAA Section 2. And I know the Superior Court was acting out of concern for the jury trial right, the constitutional right for a jury, but the Supreme Court has been very consistent there that you can't justify these rules to try to protect the jury trial right. I mean, in the Kindred case, the Kentucky Supreme Court acted out of its desire to protect the constitutional right to a jury trial in the Kentucky Constitution. The court said, no, you can't have special rules in the name of protecting the jury trial right. That violates the FAA. So we think that under FAA Section 2 and all of the Supreme Court cases that we've cited, the types of rules and the stricter burden that was adopted here runs afoul of the FAA. I mean, I'll stop there. Just quickly moving on to the merits question about these contracts. It is clear from the record that when the Chiluttis registered for and created their Uber accounts, the interfaces, or the flows as we call them in this area, the ones that they encountered would have alerted a reasonably prudent internet user that terms were being offered, the terms were available for review via the hyperlinks, and that by creating their account they were agreeing to those terms. And if you look at the flows that are in the record, you can see that in each of them, all of them, they all explain that by clicking create account or tapping an arrow, you agree to the terms. So it expressly explained the consequences of the act of clicking the button. And then in the line where it says by clicking the button and creating an account, you're agreeing to be bound, the hyperlink is in that very sentence itself. So it's not like these things are found in disparate parts of the registration process. It's all brought to one discrete either section of the registration website that Mrs. Chilutti would have seen or on the Uber app screen that Mr. Chilutti saw. The user has to go to that particular location of the website or the app, you can't avoid it, because to create an account, you must click those buttons, and you cannot create an account unless you click those buttons.
Counsel, you use the phrase a reasonable internet user. What is that? Or who is that?
Well, that's, I guess that's all of us, Your Honor.
Really?
No, I think.
That's why I'm asking
well,
you.
I
What would make you assume that everyone is a reasonable internet user?
I think what, and that's a term that's employed by the courts that have adopted the standard we urge, which is conspicuous notice and objective manifestation.
So they must have defined then what a reasonable internet user is if they use the term.
They've not specifically defined it, but they have. I think what it's indicating is that someone using the website or someone using the app screen would see that there's, terms being offered, et cetera. And I think what that is designed to take account of is you can't have a subjective standard for this type of thing, because you'll have people who are less sophisticated, you'll have people who are more sophisticated, and you can imagine.
Counsel, I mean, this is sort of a dangerous place to go, but can you account for the idea that a child might set up their parents' Uber account and assent to all the terms and conditions without the parents even knowing it? The parents get into an Uber and get into an accident. How do you account for that possibility?
So like an unauthorized registration situation where, I mean.
Again, I think it happens more frequently than you're willing to acknowledge in court, that, sometimes children help their parents fill out online accounts and Uber apps and things like that. And in that instance, I mean, that's not the facts here, but how does that play into your reasonable internet user? Are we assuming that everybody who sets up their own account is setting up their own account?
Well, Your Honor, I think you're right. This case doesn't present those facts, but in a setting like that, I mean, there are cases, believe it or not, that talk about sort of agency principles and the like in terms of when people set up accounts for other people. And the courts have found that there's an agency principle theory there that under the law can be relied upon to bind the party.
But counsel, the notion of a reasonable internet user goes to the meeting of the minds principle that you're relying on, which is why I'm really probing the question. Because I don't know who that is. I mean, there are people who may just need an Uber account because they can't get to their medical, providers any other way, and so they do what they can to set up an account and click agree, and then they move on, not realizing that what they're actually doing is entering into a rather detailed contract for services. I mean, do reasonable internet users do that?
Well, Your Honor, I think you need to have a standard, right?
Agreed.
And reasonably prudent user is one who looks at the applicable screens and and takes note of being provided an offer of terms. If you don't have an objective standard like that, it would basically undo all of this commerce that you're talking about. If every consumer could come in and say, well, I'm not a reasonably prudent internet user. I'm illiterate in those matters, so I'm not bound by my contract. I mean, that's never prevented the enforcement of contracts outside of the online context. That's never been a validly accepted defense or excuse to relieve someone of contractual obligation. So I think it's important that there be an objective standard, that the courts employ it in the fashion that we've argued, which is to understand whether a reasonably prudent person would looking at
change your terminology.
Well,
we're back to a reasonably prudent person. I mean, the reason I press the point honestly is because I agree with the basic concept that if someone is given the opportunity to review a contract, we presume that they have. It doesn't really matter if they actually have. But I'm just wondering about the saliency of that opportunity when we're talking about multiple hyperlinks within a rather lengthy internet document in the first instance.
Well, you know, the processes are designed to be less cumbersome, more efficient, allow the consumer to, you know, easily make the arrangements to register for an account with Uber. And so what Uber does in this particular instance is it makes those terms available via the hyperlink, which means that you can access those terms. You can read the contract. You can decide not to read the contract. But the law doesn't relieve you. If you're provided with the opportunity to review the contract, then you need to read it. So, Your Honor, unless the court has any further questions, I'll conclude the argument. We think that this court should not reach any of the merits questions. We think 313 is plainly not satisfied. And even if it were, the FAA has been violated here by virtue of the new stricter burden of proof and new rules that the court has fashioned. And when you put that aside, when you reject that rule and apply just ordinary contract principles, reasonable notice of terms, and objective manifestation of assent, under this Commonwealth's law, a contract is formed. Whether you read it, didn't read it, that's been the law in the Commonwealth for
Well, we probably
100 years.
have an inherent problem in society, if not in the law, that people are trying to engage in complicated transactions, generally while on their iPhone. And the reading of a contract or those terms in that setting is much different than what we originally conceived of when we talked about contract interpretation. But I appreciate your argument very much. Let's hear from Mr. Messer.
Thank you.
Good morning, Madam Chief Justices. May it please the court, I'm Joe Messa, and with my co-counsel and colleagues here, Tom Sweeney and Megan Kwok, represent the Aplts, Shannon and Keith Chilutti. I'm going to start with the merits because it's not that complicated. Pennsylvania contract law at issue here has existed for centuries before the formation of the Union, and the en banc panel applied well-settled Pennsylvania contract formation and waiver law. First, reasonably conspicuous notice doesn't exist here in a hidden hyperlink, which is smaller in font and lighter in color than the rest of the text.
Well, let me ask you, Mr. Messa, because I was intrigued by the Superior Court's crafting of a rule for bold facing or font or whatever it was. Where does that come from? What's the principled rule that you would have us articulate for how prominent? Is it a 16-point font, an 18-point font? Is it bold? Is it italics? Is it on the first page? Is it on every page? What's the legal principle that empowers a common law court to craft these specific guidelines for the how prominent a contract term must be?
Well, the requirement's not that specific, Justice, and I think also have no evidence of unambiguous mutual assent, and the argument about this stricter or higher burden doesn't relate specifically to arbitration clauses, is not discriminatory at all. It relates to a standard required, which is a higher burden in the law already when waiving a right guaranteed by Article 1, Section 6 of our Constitution.
I'm sorry, could I just follow up on that?
Of course.
how do you avoid a slippery slope problem? If we were to validate the Superior Court's line, kind of sort of looks like a stricter rule, but were we to roll that out, what are the implications across Pennsylvania for contracting generally? Given that people want to get in the market and buy all kinds of goods and services, what's the point of distinction that would allow you to prevail on this point, but not disrupt all manner of contracts, arbitration and otherwise, around the entire Commonwealth?
I think what we're talking about here, Justice, is specific to online contracts and the way business is being done in this new digital age. And frankly, if we look at other states, for example, New Jersey with the hasn't affected commerce at all. These folks know what to do. They know how to provide the information. Otherwise, why would they hide it in a hyperlink that's smaller size font, a lighter print, and a terms of an agreement in this case that is on the 10th page of something in a hyperlink when you're waiving a constitutional right? What's the reason for that other than to get people to agree to waive that right without actually being aware of it and consider it?
Presumably part of it is that that it's either that or they could open up a storefront and everybody would have to schlep into the storefront and sign a contract in the presence of a lawyer.
Well, courts have upheld these types of agreements where it says when you sign up, for example, you have to click on something that says you are giving up your right to a jury trial by agreeing to this. You are waiving a constitutional right, or the terms that are contained in the hyperlink, right by the hyperlink, that has a clear appearance of a hyperlink in blue, bold print with a blue line underneath it, that those terms include an arbitration provision or waiver of your right to a jury trial. That gets you there. It's simple for them to do. They have people that are way smarter than me that can do that.
Counsel, I apologize. How do we
Yes,
get
Justice.
around kindred nursing, U.S. Supreme Court's decision?
Well, simply, Justice, kindred nursing was struck down because it was a new rule that was articulated by the Supreme Court of Kentucky that had never been articulated before, as opposed to centuries-old contract law, and that rule related only to arbitration, as opposed to waiving a constitutional right in an online agreement where that information is not reasonably conspicuous to provide that reasonably conspicuous notice or evidence, unambiguous evidence of mutual assent. And as this court has said, the waiver of a constitutional right requires a knowing and intelligent waiver in Commonwealth versus Barnett.
That's the government. That's Commonwealth versus Barnett. That's a government case. This is private contract between two parties. The Uber did not owe your client a right to a jury trial.
No, but the Constitution guarantees the client a right to a jury trial, and this court in Bruck...
The government has not deprived your client of a right to a jury trial. The two parties engaged in a contractual agreement to provide a service, and your client took advantage, you not just signed the agreement, but actually then used the service. And no government entity has deprived your client of a jury trial. This is a matter of contract.
That right applies, Justice, not just in the governmental setting, but this court said in Bruckshaw versus Frankfurt Hospital, the constitutional right to a jury trial applies equally in the civil setting. And yes, did my client use the service? They did, but without the information.
What did your client think the terms and conditions were?
My clients never clicked on the terms and conditions or even understood them because they were in smaller font on a complicated screen, not on the first page that didn't have the typical appearance of a hyperlink. Terms and conditions could be anything.
But you're quite different from Taylor. I mean, in Taylor, it was essentially, if I recall correctly, essentially the same thing. It just wasn't online. It was, you know, people have these long contracts, and we all sign them, right? I mean, we all click through, or we see it in person and just fly through it to the end. I mean, the consequences are on us if we don't want to take the time to read them. I just don't see the point at which this infantilizing of contract parties is going to end.
Well,
and if you prevail on the merits, I don't know how we avoid hearing all kinds of litigations where somebody says, okay, I signed a contract, but it wasn't big enough font, or it wasn't bold enough, or I thought it was blue ink, it should have been red ink. Where does that end?
Well, Justice, first I would say the way we avoid that, or the way the court avoids that, is by making a clear rule that people can follow. And industry will certainly follow it if this court makes the rule. Secondly, Justice, with respect to a in-person paper contract where you sit across a table from someone who presents you with a 20-page contract, you have the terms there, they're right in front of you, they're in regular size print, you can read them, you don't have to hunt for them or find them in a hyperlink. Here, the duty to read doesn't, morph into having to go on a scavenger hunt and search for terms that are not readily available.
Even the in-person contract cases, we're seeing them come up in terms of different arguments being made about the enforceability of arbitration agreements when somebody actually signs it in person. Oh, it was too complicated, it was too broad, there's a right to a jury trial. I mean, what if there was a damages cap? What if there was something in the contract that capped your client's damages at $75,000? I mean, would you argue that that's a violation of the right to access to the courts under the Constitution and the Remedies Clause, and therefore that's unconstitutional? That has to be bolded, put in the front of the contract under a list of banner things where you're waiving a right under the Constitution?
Well, a cap on damages would be violative of the Constitution. However, Justice, that information, just like in confession of judgment clauses, has to be presented in a way that someone understands what they're waiving. They're waiving a constitutional right. This Commonwealth has allowed confession of judgment clauses for decades at least, and there are certain requirements there to waive a constitutional right. It is certainly different when you're in a conference room with someone or a real estate office or whatever it is, and you have the time to read the contract. It's there in front of you.
What if you're standing at a kiosk at a amusement park, and you've got terms and conditions about your access to the amusement park? Would that be different from this online terms and conditions situation?
Sounds like you're referring to the Santiago case, Justice, but
I'm not referring to
in that circumstance, it goes back to Pennsylvania law contract formation. Is there reasonably conspicuous notice? Is there unambiguous evidence of mutual assent? And if you're waiving a right to a jury trial, that higher burden to show knowing and intelligent waiver. And Justice Wecht, I don't think this runs afoul of Taylor at all. Taylor references Concepcion, and Taylor and Concepcion both specifically reference that the FAA accepts in the savings clause those things that are specific to state law contract formation. That's what we have here. And the United States Supreme Court recently in Morgan versus Sundance has said arbitration is entitled to no greater treatment than other contracts in a unanimous 9-0 decision. That's what we're talking about here. We're not looking for greater treatment to sublimate, for example, arbitration. We're looking for equal treatment. What Uber wants is to give arbitration this super contract status that they should be able to bind people to these arbitration clauses and waiving their constitutional right without ever having made a knowing and intelligent waiver. To continue, the en banc court's opinion indicates that the website didn't provide reasonably conspicuous notice, and there's no action by the Chiluttis that manifests mutual assent. The,
What about the continued use of the service? And I think the record indicated that Mr. and Ms. Chilutti re-upped. They re-clicked, if I'm not mistaken. They renewed one or more occasions their agreement. Is the continued use by a sentient adult, there's no evidence of intellectual incompetence here, not signal their assent to the terms of the agreement with the provider? I mean, they're not forced to use Uber. They could have walked, they could have used Lyft, they could have got a yellow cab. But by continuing to use the service and clicking and re-clicking, is that not an assent to the terms that Uber is proposing to them?
No, Judge, for this reason, because that information was never presented to them. It's the same circumstance where you have terms hidden in a hyperlink that they never knew or aware of before. You have to provide the information. There's no reasonably conspicuous notice. And that's where this all starts from, Pennsylvania contract law.
Do they have to, in the arbitration provision under your theory about this being a constitutional right and an app agreement and clicked in terms and conditions, do they have to specifically advise in some kind of a bold thing, the Pennsylvania Constitution grants you a right to a jury trial. By engaging our service, you are hereby waiving your right to a jury trial and agreeing to arbitrate. Does it have to be that specific?
No, Justice, but it provides no information. It doesn't use the term arbitration. It doesn't define, I mean, even if you get to the 10th page for an inconspicuous hyperlink, it doesn't define arbitration. It doesn't say you're giving up your right to appeal. Those two rights with regard to a jury trial, it doesn't say jury trial either, but if it defines arbitration and says you're giving up your right to appeal and you're not going to be in court, I think that's sufficient. But you got to be able to see it. You got to get there. There has to be reasonably conspicuous notice.
You still have a right to an appeal an arbitration award. It's just a very narrow view of what you can appeal. But I'm just trying to figure out does it have to specifically say you are hereby waiving X?
I think it has to provide reasonable information, reasonable notice, and that would include.
That's my question.
Yes, Justice.
Is your definition of reasonable notice not only what you're agreeing to, but what you're giving up?
I think it has to provide information about what you're giving up. You don't have the right to proceed in court, for example, or you don't have a right of appeal. It has to define what arbitration is. The definition of arbitration tells you that. I mean, it should, but frankly, the consumers don't know that. I mean, for example, you go to arbitration in a case in the Court of Common Pleas, you have a right of appeal. What do consumers know? They don't know if they've ever been in that circumstance.
You're also assuming, Mr. Mesa, that if all of this happened in this agreement, your clients wouldn't have tapped yes. If all of this had happened in this agreement and all of this was disclosed in the arbitration and everything like that your clients would not have used Uber.
Justice, I don't know because I didn't ask my client what they would have done. However, that sort of begs the question of the obligation to provide the information to form a contract for there to be reasonably conspicuous notice, unambiguous manifestation of mutual assent, and when a constitutional right is involved, a knowing and intelligent waiver. And the evidence of that doesn't exist in this case.
Follow up on that?
Yes.
Here you're making the classic fine print argument. And it is memorialized in that famous dissent by Justice Masmano about the tiny writing on the top of the Doric column. Is that the Eldridge case? I can't remember which case that is, but I'm pretty sure it was a dissent because
Lots of dissents by Justice
there
Masmano.
are, and they're beautifully written, but floridly written. But am I not correct that the fine print arguments have not gained traction in this court? In other words, coming back to this point about a sentient adult under an objective standard is deemed to have been competent to have read and signed the agreement, and we will hold, as a matter of contract law, that person bound to their agreement, absent fraud, duress, incompetence. Don't like fine print, but the courts, they don't strike down contracts on that basis, do they?
Well, I think there's two distinctions here. Justice, and one is waiving a constitutional right guaranteed by Article 1, Section 6 to a jury trial that's considered or in our Constitution is inviolate. Two is fine print in a contract is actually there, you can read, and you don't have to go on a hunt for a hyperlink that doesn't appear on the page at all, like a typical hyperlink that doesn't appear anywhere near a statement about waiver of anything that conditions, but just to sign up for the service, which is what happened here. So I see a stark distinction there, and that gets back to the duty to read issue.
Counsel, maybe I misunderstood what you said earlier, but I'm looking at
I
the,
didn't hear the beginning of your question.
I said, yeah, it is on. Maybe I understood what you said earlier, but I'm looking at the arbitration agreement, and it does in fact say that you and Uber are each waiving the right to a trial by jury. So the problem is it wasn't conspicuous enough. I mean, it says you can't go to court, you waive the right to a trial by jury. So what's the problem then? It's not the language, it's the lack of this is not the version that your client signed.
Not the
what
first
I just
version.
read to you. Okay.
No, Your Honor, and we're talking about the version my client signed or clicked to sign up for the service is on the 10th page of a hyperlink. It does reference jury trial. It does say arbitration. It does not define what an arbitration is or indicate you're giving up rights of appeal if you ever get there.
What's the difference, Mr. Mesa, between the provision that's attached that Justice Donahue was reading from and the provision, the contract that your client signed? Are you saying it was a subsequent version?
I believe,
I think I
Justice,
lost you there.
if you'll give me a moment, I can.
Absolutely. This is what co-counsel are for, by the way.
I'll take the help that I can get.
If you have a record citation, that would
I do.
suffice.
I will get it for you. It's in the record at 120A, and there's a reference to it in the brief that says, by clicking Create Account, you agree to Uber's terms and conditions and privacy policy. You can see that terms and conditions and privacy policy are smaller font than everything else on the app, as well as in a lighter color print. This is obviously blown up for the purposes of the page and readability, and no information there whatsoever about waiving anything, your right to a jury trial, arbitration, a constitutional right or otherwise. That doesn't come unless you actually have an understanding there's reasonable notice with respect to anything in those terms and conditions. Understand that is a hyperlink that's clickable, and then when you click there, you get to the 10th page of a different website.
You're not,
So
you're not
that's
just-
where
I have
that
one.
jury trial waiver language is found? On the hyperlink, if you click it?
In the 10th page. Yeah, on the 10th page, yes.
So this setup on the phone, on your phone or on your laptop or iPad, whatever, you are able to obtain a Uber account without ever clicking the terms of use button?
1,000%. All you have to do is click the create account button. You don't have to ever get to that 10th page of the hyperlink if you even know that that is a hyperlink. It's just create the account. Was there another question, or I'll move on to the Rule 313 argument? So,
Go back to the beginning.
I'm sorry?
You can go back to the beginning.
Go back to the beginning. Your Honors, Rule 313 is not the rigid formulaic rule that appellant suggests. Courts have interpreted practical considerations in evaluating Rule 313 like those recognized by the en banc panel. And we shouldn't be sublimating a constitutional right to a jury trial to a rule of appellate procedure where there is no clear path of appellate review. As such, if that occurred, it would allow the rule to devour the constitutional right.
Didn't the Superior Court itself acknowledge that the scope would be wider because you'd be, at the back end, then you'd be challenging as a jurisdictional matter whether the matter should ever have been in arbitration in the first place?
Far at the back end, with very limited possibility of getting there. For lay folks who are litigants, Shannon Chilutti was in a wheelchair at the time, and Keith Chilutti worked in labor. The way Rule 313 is written, frankly, arbitration is given preferential treatment from the outset. They have an automatic appeal from a denial of arbitration. An injured person has no right of appeal.
That's an argument with the General Assembly. I mean, they chose, they made the law. We didn't make it. They gave the right in the one hand and not in the other hand. I mean, if you're right, isn't it the case that we'll be flooded with all these? We'll be flooded with all of these front-end arbitration challenges rather than what we have now, which is we have challenges all the time after the fact. That's how, this would be a sea change in Pennsylvania practice, putting aside the statute, right?
This is why it won't, Justice, because we look at the practical aspect of this. People who are injured and their lawyers who are representing them on a contingency basis, they're making decisions based on what the evidence is, right? If there's signed a contract, it's clear they signed the contract. A contingency lawyer's not going to pursue it after that, and a plaintiff who needs compensation is not going to continue. This is very limited scope in that there has to be a situation where contract rules that have been in existence forever aren't complied with. No reasonably conspicuous notice, no mutual assent, no knowing and intelligent waiver.
But how do we get around the fact that the legislature specifically indicated that it's the denial of arbitration that's immediately appealable? Can we take that and say, well, in all fairness, if we're going to allow it in denials of arbitration, we should allow it in grants of arbitration? I mean, does that fit anywhere within the context of Rule 313?
Well, it's in the application of the rule, Justice. I mean, it's a rule of appellate procedure that I think this court controls, but there is also a statute that gives rise to the rule. But
what's irreparable? What's the irreparable? The Rule 313B says irreparable injury. What's irreparable?
Well, I suggest, Your Honor, irreparable is a circumstance like this, where lay people, a couple one of whom is seriously injured, has to jump through hoops, go over hurdles of the time, cost, the physical and emotional effort of hiring counsel, preparing for an arbitration, going through an arbitration. Then the next step is they have to attempt to show fraud, misconduct, or mistake where no right of appeal exists. And then, even with the infinitesimal chance that that could occur, go through the entire appellate process to try to get that overturned, that they didn't sign a contract or a contract that complied with Pennsylvania law in the first place, and then if they win on appeal, start all over again in court.
Well, there's two things here. First, I'm still not, two things. One, I'm still not understanding your argument that they would have to show fraud. They would be able to argue to a court at that point the argument that you're making, that you made in the first part of your argument. There's no basis for saying, in other words, that at the back end of such an arbitration, they couldn't come to the Court of Common Pleas and argue why you think, this fine print thing means that they were put out of court in derogation of the right to jury trial. So that's number one. And number two, it would seem you're arguing ultimately then that there's no tort arbitration at all. Presumably we can have contract arbitration, but there's no arbitration in the law of torts at all. Can you respond to both of those points?
Yes, Justice, I'll try to respond to them in order. First of all, the standard in the Uniform Arbitration Act and AAA arbitration, which is what this quote-unquote agreement requires, is a showing, and Rule 313, referencing follow-up of Rule 313, that the right of appeal only exists where the plaintiff can show fraud, misconduct, mistake, or other irregularity. Does the evaluation of a contract at the end of all the procedure that those folks have to go to qualify for that standard of fraud, mistake, misconduct, or other irregularity, if we even get there? That's.
If you win, though, I'm trying to sort this out in my own mind. If there is an appeal after the arbitration and you win on review of this question, should this arbitration have been compelled, then isn't the actual arbitration proceeding and verdict a nullity?
If you win, however, and I'll get back to the rest of your question, Justice Wecht, the reality of it is these things are not likely to come before this court, and the problem here involves the loss of the constitutional right, because ultimately, what's going to happen if a layperson citizen goes through an arbitration process, and in this case, Shannon Chilutti was a passenger in a vehicle in a car crash case, and goes through that process and goes to the arbitration, and as a passenger in a vehicle is likely to win the arbitration, may be inadequately compensated in that setting. That's likely, but either way, inadequately compensated or not, the likelihood of an appeal or the court accepting an appeal or giving that any countenance in a circumstance where they have to show fraud, mistake, misconduct, or other irregularity is highly unlikely, and they've lost. I'm sorry.
You're not directly answering the question that the Chief asked you, and you keep going to the let's just imagine under your hypothetical the arbitration award is terrible for your clients. I'm not willing to assume that, but let's just assume it's a terrible award. The trial court litigation is just stayed. Right. And that has nothing to do with what happens at the arbitration. Once the arbitration award is decided, you may or may not win on an appeal, but that doesn't really matter. What matters is that stay is going to get lifted, and you will then be able to appeal the trial court's order forcing you to go to arbitration. So let's focus on that and not what limited
if there is an award, the likelihood of going back to court and filing a claim to show some irregularity, mistake, or fraud, and actually exercising that constitutional right is highly unlikely to happen, including getting over those hurdles,
Yeah, counsel.
such that, I'm sorry, Justice, such that that constitutional right has been lost in all practicality.
I think we understand.
Can I just try one more time, following up on Justice
course.
Robson's question? There's an order at some docket number somewhere staying the arbitration.
Stay in the trial or
Stay in the
case.
trial court. Okay, so subsequently, there is an arbitration, there is an award. When there's an attempt to reduce that award to judgment, does that have to be filed at the same docket number as the order staying the court action pending the arbitration?
Yes, Justice.
Okay, so why isn't it then, when you're back in that trial court, who stayed the litigation pending the arbitration, why at that point can't your argument be, you stayed the litigation pending the arbitration, I'm now raising my question again, questioning the legitimacy of the agreement to arbitrate? It's a different issue than what happened in the arbitration. It's a question of what the trial court did prior to the arbitration taking place,
You can, Justice. However,
without raising fraud, whatever else you're arguing, illegality, irregularity. Why isn't it at that juncture just the trial court's original decision to stay, and you're saying there was no contract? That's what the Superior Court here was dealing with, wasn't it? Precisely that situation.
yes, but in order to overturn the arbitration award to go back to court, you have to get around those requirements, those hurdles of fraud, mistake.
But that's
I'm not sure that's the
consistent
case,
with-
though.
We've said the opposite.
Yeah.
In the Goldstein case in 1938, we held the opposite. We held that a dispute about which parties were included in an arbitration agreement was a question for the courts to decide before the arbitration award is enforced. And the Superior Court, in a 2018 case of Sivan versus Windermere, said, quote, "The narrow standard of review derived from Section 7341 is not applicable when reviewing a petition to vacate based upon a claim that the parties do not have a valid agreement to arbitrate." So, these scenarios my colleagues are asking you about, when you come back to common pleas after an arbitration with which you're not satisfied, you could certainly bring your argument about, the FAA and all this fine print stuff, et cetera. Then your argument is that these people shouldn't have to wait to bring their tort claim. But if you're right about that, then that applies not just to your case, but any case in tort.
And if I may, Justice Wecht, if that is correct, which I believe it is, then if you win on that initial appeal, the appeal of that initial issue, then the arbitration proceedings and award become a nullity. But if you lose on that issue, then you're appealing the arbitration award on that narrow standard of review.
But still, these folks have to go through all those hurdles, costs and expense, financially, emotionally, personally, and otherwise.
It's very difficult.
And that's what I referenced before about Rule 313 not being rigid and formulaic, and that practical considerations have been considered by this court. For example, in the Pridgeon case, even though there was a right of appeal for denial of summary judgment for financial reasons, when we're talking about corporate interests that don't have a problem with financial interests. In the Philip Morris case, that was a Commonwealth court case that Justice Robson participated in, and I think instructive here, although certainly not binding on this court, the Shears case, that opinion which was participated in by Chief Justice Emeritus Saylor, holding that the third prong of Rule 313B, irreparable harm, is met because the rules of AAA arbitration do not provide for a right of appeal. Here, there was also reference to the Civon case. Let's talk about Civon for a minute. Civon was a completely factually different scenario. Civon, you have Mr. Gambone, who was not a party to a contract for arbitration that refused to participate. The arbitration went ahead without him, and there was an award against him. He then was permitted to file an appeal despite the fact that he objected to the proceeding, and that was determined to be a basis for vacating the award. The Chiluttis don't have that option here. They can't refuse to participate. They're the plaintiffs. If they don't participate, their claim's dismissed. It no longer exists. And in Del Cioto, there was no agreement to arbitrate. There's no dispute, I'm sorry, that there was an agreement to arbitrate in the first place. It was a document which was signed in a contract that there was no question about reasonable notice, unambiguous manifestation of mutual assent, or the knowing and intelligent waiver of a constitutional right.
Is the, on my question about tort and contract, is your argument that that there's some principled distinction between the waiver of a jury right that might attend an arbitration agreement in the tort context that doesn't apply in the contract context? Because I'm thinking, of course, about, you know, all those thousands and thousands of securities claims that go to arbitration. Is that a dividing line that you stand on? Because they're waiving, in other words, they're waiving a jury trial, right? Could involve millions and millions of dollars.
Those are sophisticated entities and people and corporations that are waiving jury trial rights. And frankly, the FAA originally was passed because of wanting to encourage the ability for those sophisticated parties to arbitrate, not initially intended to be related to individuals like the Chiluttis in this circumstance. And frankly,
Sophisticated or not?
well,
What if these are two hyper-sophisticated people? One's the CEO of Shearson Lehman, and the other's the, you know, CEO of Kohlberg Kravis Roberts. I mean, how does sophistication figure in?
well, I think originally talking about the FAA went to business and corporate interests, but I wasn't referring to sophistication of individuals. I think you have to go back to the principles of contract formation in Pennsylvania and what's required to waive that right. And that longstanding law has been there and should be followed, and Uber knows how to follow it, and they certainly know how to change their terms and provide the information up front. They were provided a roadmap by the en banc opinion, and frankly, they've changed their website and their sign-up process since then.
All right, any other questions for Mr. Mesa? You want to conclude, sir, or are you finished?
Yes, Justice, thank you.
That was a good
Justices, for
conclusion.
your time, and would respectfully suggest that the en banc opinion should be upheld by this court. Thank you.
Thank you both. Excellent arguments, and I think for our law students, they got a nice taste of outstanding oral advocacy here. Thank you both. Want to call the next case, Mr. Minner?
City of Philadelphia versus JS Senior and CS, representing appellants, Mr. Jason Gabby, representing the city, Ms. Jennifer McNaught.
In this discretionary appeal, we must determine whether the sexual abuse exception to governmental immunity under the Political Subdivision Tort Claims Act applies only to plaintiffs who were under age 18 at the time of the alleged sexual abuse. Good morning.
Good morning, Your Honor. Jason Javi for the appellants, and may it please the court.
And you are a lot taller than Mr. Mesa, so if you could pull that microphone up. And most people, yes. And a little bit higher, that'd be great. Thank you, sir.
Yes, Your Honor. In determining whether the sex abuse exception to the Local Political Tort Claims Act applies to adults and children alike, this court need look no further than the plain language of the statute that was enacted by the legislature. The language at issue reads, "Conduct which constitutes an offense enumerated under section 5551, subsection 7, in parentheses, relating to no limitation applicable, close parentheses, if the injuries to the plaintiff were caused by actions or omissions of the local agency which constitute negligence." The term conduct is defined in Title 18, section 103. Conduct is limited to actions, omissions, accompanying states of mind, or where relevant, a series of acts and omissions.
Well, you say the plain language, so it says 5517, and we turn to it, it limits it to victims under 18 years of age at the time. So why doesn't plain language defeat your argument?
So there's a couple of different answers. The first is it's a cross-reference to the list would be my position, meaning that the legislature in subsection 8542B9 is specifically pointing the court or the reader to the list of the offenses, not necessarily the preamble to the list. But even more importantly, when you get into the definition of elements of the offense, conduct, the age of the victim, statute of limitations would be an attendant circumstance, not conduct that amounts to an offense.
But can't the legislature, would you agree, sir, that the legislature has the power to sculpt and shape punishable conduct by various categories, including the age of the victim? And in fact, that they've done that elsewhere in the crimes code.
And I think that that's 100% correct. But what's telling about this particular statute is the use of the term conduct as opposed to conduct and attendant circumstances. When you're talking about an offense, whether it be, we could just pick one from the list, involuntary deviant sexual intercourse, there are certain subsections of that statute that do require the Commonwealth of Pennsylvania to prove the age of a victim beyond a reasonable doubt. But that is what would be called an attendant circumstance, not conduct.
We can call, one more thing then, we can call it an attendant circumstance, or we could call it the cat in the hat, but if we agree with you, then aren't we directly flouting what the General Assembly is telling us? In other words, we're doing the opposite of what they said, because the opposite of under 18 years of age is over 18 years of age, right?
Well, I suppose I would answer that question in this fashion. If the court believes that the intent of the legislature Section 8542B9.
Counsel, share with us, why would the General Assembly have just not make reference to those sexual statutes that it wants to include as opposed to containing an age qualifier? It specifically refers to 5551 Section 7, which includes
true, except that it's not all of the sexual statutes. The statutes that are listed under 5551 subsection 7 are what I would characterize as some of the most serious and heinous of...
SORNA does the same thing.
I'm sorry?
Our SORNA, the sexual offense registration, lists the most serious offense or not.
Correct.
But the issue becomes one of SORNA is used for registration. I'm still not understanding your argument that we are to exclude the age qualifier from a direct referral to a statute by the General Assembly, which is based upon the age qualifier for its implementation and application. How do you get around that? You're asking us, as my colleagues at the other end said, you're asking us to cut the statute in half and just say, oh, these are the offenses and not qualify it by, these are offenses conducted against a minor, which waives the statute of limitation.
So I don't think that it asks the court to cut the statute in half because, again, the way that B9 operates is it cross-references the list. Section 5551, subsection 7, is a completely operable statute insofar as it concerns the statute of limitations for a criminal prosecution of those offenses.
So is it your argument that 5551.7, that statute is ambiguous?
No, sir. The statute is not ambiguous because, I mean, it says what it says. It says that in a criminal prosecution for the following offenses, when the minor victim is under 18, there is no statute of limitations. That's what that says. Subsection 8542B9 has nothing to do with the statute of limitations. That carves out...
It does say an offense enumerated, an offense enumerated under section 5517, right? That's what it says.
It says conduct.
No, conduct which constitutes an offense. So it has to be conduct that is an offense enumerated under section 55517, right?
That's correct.
And the offenses enumerated under 5517 are offenses where the statute of limitations is waived, where the victim is under 18.
I mean, that is correct. In the criminal. I
understand what you're suggesting, though, is you're focusing on conduct. But where I think we're struggling and why we're asking these questions to you is because if the General Assembly specifically wanted to say immunity is waived for these criminal offenses, they would have done exactly what they did in 55517 in creating a list. But how are we to interpret the intent of the General Assembly by not referring to that list, meaning 5517A through whatever, and referencing just 7? I mean, there has to be an intent behind that. And that statute was created specifically to waive immunity. It even says it with regard to waiver of immunity for offenses against juveniles. How are we to interpret the General Assembly's intent for referring to that as opposed to the Crimes Code provisions?
So 55517 doesn't waive immunity with respect to juveniles.
Waives the statute of limitations.
Right.
Right.
And so it goes back to the use of the term conduct as opposed to conduct in attendant circumstances.
Conduct which constitutes an offense
Correct.
And the only offenses enumerated under 55517 are offenses against juveniles.
That's incorrect.
It
because,
says juveniles. It says under 18, where the victim is under 18.
well, that would be an attendant circumstance. But rape can be, which is one of the enumerated offenses, can be committed against an adult.
True, but the statute of limitations is not waived for a rape against an adult.
In the criminal context, I would agree.
Okay?
And then if I could just continue with, when we're talking about the attendant circumstances, that's defined as including the description of the forbidden conduct and the definition of the offense, which would be your...
Why do you get, just to follow up, why do you get to have the parts of 7 that you like and not the part that you don't like? The legislature said enumerated under section 5551(7). And then we go to 5517. It seems to me your argument relies on asking us to say, give me the part of 7 that I like, but not this other part. Aren't we required to apply all of what the legislature told us and not just the part you want us to apply?
I think the disagreement, if you will, that I have with some of the questioning is that my position is the legislature didn't tell you to apply that whole, the entirety of subsection 7. The statute specifically points you to the list of enumerated offenses. And it would make no sense to talk about a criminal statute of limitations in the context of a waiver of sovereign immunity, because it doesn't offer or add anything.
Well, sure it is, because I think what the General Assembly is saying is just as we created an exception to the statute of limitations for offenses against juveniles, we are also going to waive immunity for offenses against juveniles. That's why they're linking the two. Why isn't that what the General Assembly intended?
I think it comes down to the way that they wrote the statute. And again, I go back to the
But you're just
conduct.
saying there's no logical connection between immunity and statute of limitations, and I just gave you a connection. The General Assembly said if we're going to waive the statute of limitations for prosecuting these crimes against juveniles, we're also going to waive sovereign immunity for civil liability, like for crimes against these juveniles. Why isn't that a logical connection?
Because they don't talk about attendant circumstances, and attendant circumstances would be what the age of a victim or facts that implicate the statute of limitations.
Counsel, why should this court not be guided by the federal case of Jeans versus City of Philadelphia, which interestingly is a sexual offense at the very same institution, CFCF?
So I addressed Jean in my briefing, both in this court and before the Commonwealth Court, and I say it with the utmost respect to Judge Rubino, because I respect him as a justice. I don't think that he grappled with the finer points that I'm trying to make in his opinion. He seemed to equate age of the victim with conduct, and I think when you go into the way that the legislature defined the terms conduct, the terms attendant circumstances, that his syllogism, or that his logical reasoning does not stand up. Because again, if we're focusing on conduct, conduct is something that an actor does. It's not facts and circumstances that are not in that actor's control. And I would say that age is the perfect example of that. Because while certainly an abuser could pick a victim, the abuser is not, the conduct of the abuser and the state of mind of the abuser has nothing to do with the age. That's what conduct concerns. And so when Judge Rubino rather, I would say concisely, said that age of the victim is part of what criminalizes the, age of the victim is part of what criminalizes those offenses. I think that that's incorrect. The other thing that and it's sort of an argument that I made much more strongly before the Commonwealth Court because it kind of came up a little bit differently. The statute of limitations, the way that this court has explained the statute of limitations, is it's not really, you don't really have a right to the statute of limitations. The statute of limitations is something that at a certain point in time will cut off the ability for a prosecution to be brought. But the fact that the statute of limitations is run doesn't mean that conduct is any more or less criminal than it was at the time that it occurred. And so that's yet another reason why I think focusing on the statute of limitations, it kind of ends, you end up with an absurd result. Because somebody that was raped, for example, after a certain amount of time, maybe the statute of limitations comes into play and that person can't be prosecuted anymore. But it still doesn't mean that there wasn't a rape. There very much was, and it was very much illegal. With respect to, and I know that it was alluded to in the city's brief, and some of the questions here have alluded to it, that asking this court to sort of regard certain language as surplus or surplusage. I would respectfully submit that this is a different circumstance because of the way that a cross-reference works, meaning that it's a fully active statute and there's a list or something in the statute that the legislature decides to reference. And that's what happened here. It was the list. Another point that I think was raised, and I want to touch on it briefly, is the issue of the parenthetical. I cited in the brief to the legislative drafting manual because my opponent has made much of the fact that the parenthetical was included in section B9. And my position with that is that really adds nothing to the court's analysis because that's what is supposed to happen whenever the legislature references another section. The unsworn falsification for authorities is one where you'll see that listed relating to unsworn falsification of authorities. It's just a stylistic requirement. Assuming that the court thinks that the legislative history is important to go into, I have a couple of points.
So let me, before you approach it that way, let's approach it this way.
Yes.
Let's assume that we find this ambiguous. What's your argument?
So I think that even if the court finds it ambiguous, I still think that the term conduct should weigh heavily in the court's mind, because the legislature is focusing on conduct rather than.
We found it's ambiguous. Assume we found it's ambiguous. What would you tell us to look to resolve the ambiguity?
So I would ask you to think about the way that statutes can be cross-referenced, meaning that just because a statute is cross-referenced in a particular piece of legislation does not indicate an intent for the court to wholly incorporate that cross-reference into the statute. For them is evidence of the limitation that this statute is supposed to have. My argument, or I would ask to posit, the fact that a legislator or even the legislature passes a statute seeking to attack a problem does not mean that they're seeking to attack only that problem and no other problem. And I think that there are countless examples of that when you see the way that legislation comes up for crimes. I was preparing for this, the Paul Miller Law, which is about to come into effect. It deals with texting while driving. And that was enacted after there was a horrible crash involving a truck and a driver who was on his phone or on an iPad, something like that. If in a month I get stopped because I'm on the turnpike texting in my car, it would make no sense for me to try to defend in court saying, well, look, that statute was enacted because there was this truck crash. And I wasn't driving a truck, so it doesn't apply.
Well, what if that statute said something about it would be absurd, of course, but if the statute says something about the age of the texter, right? Then you would, I mean, if it said, it only applies to people under this age or only people over this age, right? Then your argument would not hold water, right?
Well, and that does take me to my point. When you have a statute that is specifically geared towards a specific problem or a specific class of people, it ought to say that. In this particular circumstance, that's not what you have. You have a statute that talks about sex abuse, and then it talks about conduct, and it refers you to another.
Then it seems your argument, if you were to prevail, it would seem your argument then would put into doubt the applicability of a whole range of statutes that the General Assembly relies on to cross-reference other provisions. What would they have to stop cross-referencing other provisions and instead start enumerating everything they mean to include?
No, sir. No, sir. Because I don't think that there's a problem with cross-referencing. Where I think the problem comes in is when you have a statute that cross-references another statute, and now we're trying to read things into it in terms of figuring out what it says, when indeed the cross-reference is unambiguous. It tells you exactly what to look at, a specific list, not the whole statute.
We would be reading into it if we invented this under 18 thing. But we're not reading into it, we're reading what they wrote. And they said under 18.
Right. But that's, and I would agree, that if the statute said sex abuse of minors, or if the statute talked about, put an age qualifier in it, in subsection B9, then that is clear intent, that is a specific intent of the legislature to cabin this exception in that fashion. But that's not what we have here. We have a statute that talks about sex abuse, it talks about conduct, and it gives you a list of offenses that you're to look at to determine whether sovereign immunity has been waived in that particular circumstance. The other issue that I know was raised in my opponent's brief and something I wanted to address was the concept of the public fisc and whether or not the legislature is intending to, I guess, should I put it, make public private rights of action or things of that nature. And what I would suggest to the court is that when you're looking at this particular statute, this is not a situation where if the court concludes we're correct, that now the floodgates of litigation would be opened. Because this does not make the local political subdivisions insurers for sexual abuse. In order to recover under this section, there needs to be negligence on the part of the particular political subdivision. And what that would be, knowledge, however it would come up in a particular case, you would still need to show culpability on the part of the political subdivision. So I think it's a misnomer to suggest that if this court were to say, yes, Mr. Javi, your interpretation is correct, that the legislature hasn't really indicated that it only applies to minors, that all of a sudden there's going to be a flood of litigation. And unless there's a serious problem of sexual abuse going on in political subdivisions, I just don't see that being an issue, especially because it's incumbent to show negligence on top. The one other area that I wanted to make sure that I addressed was the Muth amendments. And I actually think, and I know that my colleague points to the Muth amendments as evidence in support of their position, but I think it actually does the opposite. There were two particular amendments that were advanced by Senator Muth, one of which would have added subsection 8 to 42 PACS section 5551. That amendment tellingly would have waived the statute of limitations in criminal cases for all of the same offenses that were listed in 55517, with the exception of two. Statutory sexual assault wasn't there, nor was the specific subsection for human trafficking that pertains to minors. And in addition to that amendment, Senator Muth also proposed putting a cross-reference to that proposed subsection into 8542B9. And I think that you would need it there, because in that circumstance, but for that, in the inclusion of that, there would be a lot to be read into the fact that only subsection 8 was cross-referenced rather than both subsection 8 and rather than both subsection 7 and subsection 8. And I think that that shows that indeed there was not this desire to only limit this to minors. Perhaps minors were something that the legislature was thinking about, but like so many other circumstances, they passed the statute to deal with an issue, but it also can address other things.
Counsel, I'm really straining to understand your logic. So 5551.7, let's say we excise the preamble, which brings in the age qualifier.
Correct.
And the statute just lists the enumerated offenses. That holds weight, but you're asking us to not excise the portion of the statute that indicates that a prosecution for these enumerated offenses, provided that these offenses are against a minor, you're failing to address that issue. What you're asking us, as Justice Weck said, to cut out that part of the statute which you don't like, when all the General Assembly had to do was not introduce the preamble of age qualifier and just list the 18 pardons section of sex offenses under the 3000 series, maybe 4000 if they want to include incest. So I'm really distracted by how you're trying to share with us that it's not the statute is not ambiguous, but your argument is that it's ambiguous because we're applying it incorrectly because we're not taking into consideration the age qualifier because the General Assembly mandated that we do. Does that make sense to you? Because if it doesn't, that's exactly what your argument's doing to me.
So then, Justice, let me try to clear up what I'm saying then, because that's not what I'm saying. What I'm saying is the legislature enacted Section 5551, subsection 7, with the intention of addressing the criminal statute of limitations for the prosecution of those offenses. At the same time, there's another subsection of Title 42 that deals with the sovereign immunity, and specifically the waivers of sovereign immunity. That statute says that sex abuse is going to be an exception to sovereign immunity. Then what that does is it says to determine what particular, to determine the particular contours of the waiver, what we want you to do is we want you to look at the offenses that are enumerated in Section 5551, subsection 7.
And why would it say that when it could just make reference to Section, what is it, 3301, 3121, 22, 23, 24? It makes no sense. You're talking about cross-referencing. Well, a direct understanding would be a direct reference to the statutes of the criminal offenses that the conduct that they're waiving.
I mean,
lifting the statute of limitations.
so I suppose the legislature could have, in Section 8542B9, listed the specific subsections of the Crimes Code. It could have done that, but it's just as easy if they have a list that they like to point to that list.
Saying that we'll waive statute of limitations for offenses against minors.
Well, that's what 55517 operates to do, independent of sovereign immunity. Where sovereign immunity comes in is they're focusing the court or the reader's attention on a list of offenses as opposed to relisting the offenses there.
Mr. Javy, you make a very nuanced argument, which I may not completely understand, but I'm going to give you the opportunity to give a concluding statement.
So, Your Honor, in conclusion, I'd reiterate what I said. I would ask the court to look at the plain language of the statute, look at the way that conduct is defined, look at the way that attendant circumstances are defined, look at the way that the elements of the offense is defined. And what the legislature did here was the legislature waived immunity for conduct that is basically amounting to a number of crimes that are listed in subsection 5551(7). And I would ask that you reverse the Commonwealth Court and enter judgment on our behalf.
All right, thank you very much. Let's hear from Ms. McNaughton.
Chief, real quick.
Oh, surely.
Public service announcement. Paul Miller's distracted driving law is in effect in Pennsylvania. So just wanted to point that out in case anybody was watching your fine argument and believed that they could text and drive right now. Nope.
Thank you, Professor Braccia, for bringing your students. I hope they still want to be lawyers. Okay. Ms. McNaughton?
Good morning, Your Honors. May it please the Court. Jennifer McNaughton for the City of Philadelphia. Limitations provision. that provision starts with an age qualifier. The victim must be under 18. The simplest explanation is that the General Assembly meant to incorporate the entire limitations provision, including that age qualifier. And at least 12 other courts have read that statute in that manner, plus the Commonwealth Court here, plus the trial court here, which reversed its own decision, overruling our preliminary objections. So, versus I am not aware of a single case where a court has interpreted the Ninth Exception or the Sovereign Immunity Act exception in the manner that Mr. Javi is arguing.
Counsel, can I may be that one person who might see this otherwise. Because I don't see that subsection 9 incorporates 5517. It incorporates the offenses enumerated in 5517. You are reading subsection 9 to say conduct for which the statute of limitations is waived in 5117. That's not what it says. If it said that, you're then capturing the limitation to conduct directed toward minors. But that's not what this does. It talks about the offenses enumerated under that section.
Well, the entirety of the phrase is conduct which constitutes an offense enumerated under Section 5517. Those offenses are enumerated under Section 517 with the age qualifier at the top. So reading that section, you don't even get to the offenses until you
I disagree with you.
have read
I think that there is an argument to be made that actually the qualifier has nothing to do with what subsection 9 is talking about. Subsection 9 is talking about the offenses enumerated under 5517, not the qualifier. Because it would have been easy to say, conduct for which the statute of limitations is waived in 5517. That captures your limitation of conduct directed toward minors. Or it could have said conduct encompassed by 55171, which once again captures the qualifier. But when they refer to specifically to the offenses enumerated under that statute, I have a hard time reading it any other way than to look at the offenses that are enumerated.
Right. Those, I think as Justice Dougherty and Justice Robson pointed out, those offenses don't simply reside under that section. They already exist in the Crimes Code. They were listed under that section with the age qualifier. Now, if the General Assembly in the Ninth Exception had simply referred back to the Crimes Code, created a similar list, and not included an age qualifier.
But why isn't that what they did when they refer to specifically conduct which constitutes an offense enumerated under 5517? There's an enumerated list under 5517. Why isn't that just incorporating those offenses?
Because I think the key language is under 5517. It's only under 5517 if the victim is a minor. And that list, I mean—
That's not what this says. I mean, I understand how you and everyone else is apparently reading this, but I think that reading takes out the specific reference to the offenses enumerated under that statute. There is a list enumerating offenses. 9 is referring you to the list of offenses that are enumerated under that section.
And respectfully, Your Honor, the reason that they are enumerated there is because of the age qualifier, is because the General Assembly was—
Isn't it because, counsel, they could, instead of saying enumerated under section 5517, they could have said enumerated under sections 3011, 3012, 3121, etc., which would, under those circumstances, appellant's counsel would clearly prevail here, right? But they didn't. Instead, they used reference to 5517, which contains the age qualifier. Isn't that the distinction?
Exactly, Your Honor. Again, these crimes already existed. 55117 does not define those crimes. it takes them and applies an age qualifier to them. So to be an offense under that section, that age qualifier has to be met.
You're saying that the list of offenses is only offenses against minors?
In 5517, right. They only appear there with the age qualifier minors.
I greatly respect Justice Donahue and her views on this. So much so, I'm willing to ask you, if her interpretation is reasonable, or her proposed interpretation, what she's thinking about, and my interpretation is reasonable, or your interpretation is reasonable, or whoever's interpretation is reasonable, contrary, that by definition is an ambiguous statute. You still win, right? Because waivers of sovereign immunity have to be narrowly construed, in which case of those two, we take the most narrow construction, right?
Yes, Your Honor. In addition to that general principle for interpreting the Tort Claims Act or the Sovereign Immunity Act, we also have a very remarkable legislative history here.
Well, I don't think you ever want to go, I mean, I'm not a big fan of, I don't believe there's too much legislative history in Pennsylvania. What one legislator says or what amendments they offer is one legislator's view of the world and is not true legislative history.
I think that's true, except we have a lot more than one. We have just the breadth of discussion in the legislative history regarding this bill it's overwhelming. It's all about protecting minors.
You're not going to hit us with the wise old gentleman from Cambria County, or the much esteemed vice chair of the Judiciary Committee, or something like that.
No, Your Honor, but clearly this was an issue that was of great personal importance. Two of the legislators spoke up and said that they were survivors of child sex abuse. So clearly this was what was on the minds of the legislators, versus there was not any mention of sexual crimes against adults and waiving immunity for that. So, and again, to briefly point to the Muth amendments, Senator Muth clearly interpreted the bill, the House bill, as protecting children only. And she proposed amendments that would have expanded the statute of limitations reform and the immunity waivers to adults, and those were voted down.
And
So-
if the legislature intended or wants to broaden this, they certainly can revisit it.
Absolutely, Your Honor. And I think the legislature here, the General Assembly, had a tough job for themselves. These immunity acts, they have to balance the need to protect the public fisc on the one hand against a strong desire to aid victims of wrongdoing by government employees. But that's exactly what the political branch of the legislature is for. And if we look at the thought and the care that went into the initial drafting of the Tort Claims Act and the Sovereign Immunity Act, the fact that we had the Joint State Government Commission that was convened to study this issue and study the plausibility of insurance against torts, and the debate that went into this bill, I think we can see that the legislature did not take this role casually. They struck the balance that they struck. They used the language that they used, and we're simply here to apply that intent.
Any other questions for Attorney McNaughton? Thank you both very much.
All right, thank you very much, Your Honors. Just based on the plain language, we respectfully request that the court affirm the decision below.
Thank you. Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Bazille Outlaw, representing Mr. Outlaw, Mr. Aaron Marcus, representing Commonwealth of Pennsylvania's career, representing amicus from the General's office, Mr. Phila.
In this case, appellant, who was a spectator at a suppression hearing, was convicted of direct criminal contempt after he called a trial judge a profane name in open court, which I will not repeat. We granted allowance of appeal to consider whether a single act of profane name-calling directed at the judge is sufficient to sustain a conviction for direct criminal contempt. Good morning.
Good morning, Your Honors, Madam Chief Justice, and may it please the Court. Aaron Marcus from the Defender Association of Philadelphia on behalf of Bazille Outlaw. And Your Honors, number one, I did not intend on repeating the phrase. Nonetheless.
Thank you.
You're welcome.
Or I'll hold you in contempt.
The lower court, Your Honor, and amicus suggest it is a nearly per se criminal offense for a person to insult a court using profanity if the judge simply happens to hear it. no matter the effects.
Wait a minute, he said it to the judge, though, right?
The record in that respect is not actually particularly clear. It was said in the room. The judge says it was directed towards the court. Whether it was presented to him or to her is a question of fact, and actually I would submit to this court that the record from June 16th, 2022, which is what the court considers the contempt hearing, amicus considers the contempt hearing, we consider the contempt hearing, despite the court saying the next day that I didn't, that I held him in contempt, but not that day. The record is a little...
It's a scant record.
It's a very scant record. It is, yes. The transcript is included. It was initially certified by the trial court and labeled as an exhibit in the certified record from the trial court to the Superior Court. That is one of the reasons why the Superior Court originally, in their September opinion, claimed that the McLean transcript had not been submitted for review. They overlooked that it was submitted, but simply labeled as an exhibit, not as transcripts. That's why the court then reconsidered upon our petition, but nonetheless reached the same incorrect result, in our opinion. But let me simply say that for more than a century, profanity or insult alone has never been sufficient to impose a conviction for criminal contempt where the defendant in those cases did not also cause a significant, actual, or at least an imminent disruption of the court's proceedings. Well, the actual or an imminent disruption, I think, can be defined or at least narrowed to the most simple terms that go back 100 years to Cook, which is the U.S. Supreme Court case, about whether the court can continue to conduct its business. Is there an obstruction to its proceeding that prevents a court from acting fairly?
For how long? Can you give me a temporal limit? I mean, we've all been in a courtroom where we've heard something in this instruction. If this guy had stood up and said what he said in front of a jury, and I had to ask the ladies and gentlemen of the jury to step back, would that be an obstruction of justice under your argument?
It could be in particular circumstances, yes, Your
Honor. If it could be, anything could be. I'm asking
you
under what your argument is, would that be an obstruction of justice?
If they stood up in the middle of a trial and made the same remark, right, to a jury, to the judge, and then walked out of the room, I think that could be contempt, because the design of that, the intent is clear, right? It was designed to interrupt the court. So the misconduct is present, the intent is present, and the disruption, right, could be sufficient where it's designed to impair the jury, right? I would suggest that if it was boisterous, if the defendant immediately walked out of the room, then maybe not sufficient if the judge would say, ban the person from the room, instructs the jury to disregard, and then warns anyone.
Following Justice McCaffrey's comment, if it were a waiver trial, those scenarios, no jury, just a waiver, does that constitute obstruction?
I would think not. I think that.
Why should there be any more or lack of respect because it's a waiver trial as opposed to a jury trial?
Well, let me step back for a minute. I actually think that in this particular case, if we're talking about disruption, if the defendant, whether it's a jury or a waiver, stood up in the middle of a hearing while the jury's in session or the judge is hearing the evidence and said the same comment and then walks out of the room, I do not believe if the judge simply warns the rest of the audience no further outbursts will be tolerated, and any further outbursts will result in a contempt, so there is an adequate due process notice, there is assurance, and then somebody follows up and continues, that would be contempt.
So we have to give them a one strike. In other words, we've got to warn people now that they shouldn't come into a courtroom, stand up in a proceeding, and say something out loud disparaging about a judge. Well, that's the first strike. We have to give them one strike and a warning and due process before we can hold them in direct contempt.
Not just disparaging, but exceedingly profane.
I would suggest
that theory. Correct me if I'm wrong. In this particular scenario, Her Honor instructed the sheriffs, stop court proceedings, instructed the sheriffs after a discussion as to the content of the comment, and it required the sheriffs to go outside and then bring the individual back, correct? Am I factually correct?
I think that's somewhat incorrect, Your Honor.
So what are
The facts of the case is demonstrated on the June 16th record. And I think the case law is very clear that what the court says in her opinion and in post hoc representations are not the record that are sufficient. Commonwealth v. Africa, which we cite in our briefs, which then cite Commonwealth v. Young, make it very clear that the record is what happened at the hearing itself, the contempt hearing, not the opinion. What the record indicates is that after the court recessed is when Mr. Outlaw stood up and made his comment. The sheriff was...
People were in the room. People were in the courtroom. The court was still in session.
Yes, I would agree that people were in the room.
Okay.
Yes, there is no dispute about that. The room where it happened, yes. People were still in the room.
Counsel, the trial court made findings on the record at the hearing on June 21.
Correct.
Did anybody take any exception to her findings?
No, for several reasons. First of all...
We can't live by this. We can't believe that what she says actually occurred.
Well, first of all, as I just suggested, that was not the contempt hearing. The judge's statements at that hearing, which were meant to be the sentencing hearing, right, had, according to the court, she had already found Mr. Outlaw in contempt.
Well, the sheriff had given testimony that agreed with what the judge had heard.
The sheriff on...
At the contempt hearing.
Yes, Your Honor, but on June 16th, right? So the June 16th record is what I'd suggest, and I think our case law is very clear. This court's case law in Africa and Commonwealth v. Young make it clear that that is the record we are looking at, which also would include the McLean transcript, the notes of testimony from the suppression hearing that was occurring that day for which Mr. Outlaw was a spectator. The sheriff did testify, and the sheriff simply says that, you know, someone got up, made remarks, then Mr. Outlaw got up, walked out, and made his comment. And the judge...
While he was in the courtroom, made the comment, yelled the comment, the judge is a blank.
The yelling is not indicated in the record at all. It becomes more... The court, in her 1925 opinion, makes sort of adds emphasis to the degree level of comment and changes the evidence from what was presented on the record on the 16th to occurring while she was making her findings, before the findings happened, while they were still talking. That is not in the record, Your Honor.
In any event, it was not so loud as to prevent the judge from saying, quote, "What did you say?"
That is correct.
So she heard something. She pretty much heard what he said, but it wasn't a yell, because otherwise, presumably, a judge wouldn't say, "What did you say?"
I don't know. If someone called me that, I would probably say, "What did you say?"
Yeah, I have to...
We have never contested the record, Your Honor, that the court statement from the 16th is strongly suggestive that it was heard by the court.
Well, look, I think all of us can agree that what he said, which is undisputed, was improper, offensive. I mean, add whatever.
No dispute here, Your Honor.
I want to, if I could just bring it back to the statute.
Yes.
Where you live.
Where I live, yes. Authorizes the court to impose this penalty, misbehavior of any person in the presence of the court, thereby obstructing the administrative justice. Now, I don't know how we went from the statutory language to what the Supreme Court has said. What this court has said has to be a significant or substantial interruption of proceeding. I'm not sure how that jives with the language, but I'll go with what the court has said. I was confused by the record, and it seems to me that, as far as I can tell between you all, everybody sort of agrees that this happened during a recess. And if it happened during the recess, maybe the judge was physically still there because the judge didn't get off the bench or whatever, but the court wasn't there. The court was in recess.
The court was in recess, and that's particularly important, Your Honor, because the proceeding itself, the thing that was the business of the court,
Which is
was
what the Supreme Court, which is what our court has said you focus
Correct.
on is a proceeding has to be interrupted, even though the statute doesn't say that. The statute says administration of justice, but we have said a proceeding. There was no proceeding going on, correct?
That is absolutely correct. The proceeding was in intermission. It was a recess when this occurred, and we have.
You say that, but it's not clear from the.
Oh, I agree.
People were still in the courtroom.
People were still in the courtroom. Here's a good part of the record to look at to help make that point clear. I believe it's on page 43 where the amicus points out of the McLean transcripts from June 16th, in which the court points out, and the amicus suggests there was a brief interruption in the process or in the proceeding, where there isn't a parenthetical by the court reporter. It says, interruption in court, and then the court crier simply says, I know you're not talking, and proceedings continue. Right? We know that the stenographer was very much not only capable but willing to indicate interruptions in the proceedings and did not for any indication of that when Mr. Outlaw made his comment. In addition, right, we know that that recess, despite the court's opinion suggesting that Mr. McLean's recusal request was for because of potential bias concerns, the recusal was about a jury versus a waiver and talking to client after a motion, and whether if it was a waiver, because the motion to suppress, he needed to speak to his client. What happens, though, is we remarkably have timestamps for how long that recess actually lasted, simply because counsel decided to tell the court what time it was. It was 4:35 prior to taking a recess. Then they come back after recess when all of this supposedly happens, right? When we know Mr. Outlaw stands up, makes a statement, and leaves, and then voluntarily returns during that period later, and he apologized to the court. And then the court immediately recommences its business, its proceedings. The case is rolled till the next day, and there is no reference of any disruption, any impairment of its business. Nothing occurred during that recess.
That doesn't make it right. That doesn't make it right.
I'm not suggesting it was okay.
What I'm trying to figure out is, it seems to me that we could say that the General Assembly meant to encompass any event that obstructs the administration of justice. And I could say that even under the statute, that might include an outburst in a courtroom where even a court is in recess if the judge is still there, because one could argue an insult to a judge in the middle of the public is a obstruction of the administration of justice in the most general sense. But under our precedent ties it to a proceeding. And so, for example, if Justice McCaffrey was giving a CLE in a courtroom and standing up in front of everybody, and someone walked in, and not that this would happen, yelled a profanity, no one would suggest that Justice McCaffrey could hold that person in contempt under this statute.
He might knock them out.
He might knock them out.
Right.
Tackle them.
I agree with that, Your Honor. The proceeding.
I also want to note that I have given CLEs in the past.
And I'm not trying to encourage anyone to belittle Your Honor's CLEs. I'm sure they're wonderful.
Correct me if I'm wrong. Is this the end of the court proceeding, or was this the end of that particular case? Was Her Honor did she have additional cases to hear?
No, this was the end of the day. This was the last case on the list. There was no further business other than to address Mr. McLean's decision about whether he wanted a waiver or a jury. That was it. That was the only question. Nobody discussed this matter that occurred during the recess in that conversation, beyond the court simply asking Mr. McLean's counsel, hey, sir, would you mind maybe sticking around because I've got some business I'd like you to address, which by implication suggests she wanted to talk about this case.
Mr. Marcus, I don't mean to interrupt, but I want to kind of circle back a little bit to what Justice Brobson was saying.
Sure.
And I want to make sure I understand your argument, because we have to write an opinion.
Yes.
So it's your opinion that if the court is in recess, and my understanding of this particular event was that there was a motion to suppress, judge denied it, put her facts and conclusions of law on the record, and said this court will take a 5-minute recess. At that point, your client stood up and said something. Is it your contention that if the court is in recess, there can be no conduct that significantly disrupts or obstructs justice?
Not as a categorical rule. That's not my position, because some of your honors, some of this court's cases have suggested that when the court is in break, but in the midst of a proceeding, for instance, if a fight breaks out while the court is not.
Exactly what I was thinking. A fight
Yes.
breaks out in the hallway. We've seen that happen 1 or 2 times, right?
So, I mean, Commonwealth v. Moody is sort of a perfect example, and that's probably a more recent case that is familiar. It was prior to the commencement of the actual hearing. The witnesses had not yet been called, but had entered the room, right? At that point, you have a fight that breaks out after some argument back and forth, but it was a 3-hour delay in the hearing to commencing. That was a disruption because it prevented the court from conducting its business in an orderly fashion.
Aren't
And-
we,
Point would be,
excuse me,
just- can I
I'm
just-
sorry.
No, go ahead, Justice.
Aren't, under that rule, aren't we just encouraging people that the rule is just wait till the hammer goes down and they say in recess, and while the courtroom is all filled and we're still sitting on the bench, you have carte blanche to throw any type of epithets to us?
No, it's not an encouragement.
Vulgar epithets.
It is not an encouragement of that. There are sanctions. Well, certainly there are sanctions less than contempt. A defendant who says that during a recess, who is a spectator, for instance, versus a defendant themselves or a party to the case, let alone an attorney, right? But a spectator, they're there because they want to act as support and see, and they want to support their friend or an acquaintance or a party or simply observe the court. Initial sanction is removal from the room and chastise everyone else. Further outburst, further statement, right, that is presented to this court. So you have that warning, and it would cause further disruption, right?
Aren't they the facts here? In fact, there were women in the courtroom along with your client, and there were comments or heckling, and the judge had to indicate that the courtroom better be relaxed and stop it.
So
It culminated in this comment.
So again,
So why should we not take, as we always say, the totality of those facts into the understanding that that was an obstruction and the judge tried to ignore it but had enough of it?
so one, I'd suggest that they're not the facts. What the trial court says regarding the other actions by individuals, such as detaining somebody and taking a phone, those are not the facts of the record. That's what the trial court says in their opinion. They do not appear in the McLean transcript. They do not appear on June 16th at the contempt hearing. Commonwealth v. Africa is I think, perfectly analogous in this situation. In Africa, this court reversed contempt despite nobody disputing, right, that it was very clear that the defendants in Africa had repeatedly committed disparaging remarks, all with the design to impair the fairness and the proceeding during the trial itself. But the judge had waited till after the end of the proceeding that day, held the contempt hearing, and stated nothing on the record. And the remarks that were later indicated in the opinion that were the basis of the contempt did not appear in the underlying record from the actual hearing. And this court reversed the contempts because due process requires that this is a criminal conviction. It is the trial, the hearing, the statement of record by the judge at the time of the conviction that results in what evidence is sufficient or insufficient for the criminal contempt. Nonetheless, in this case, you do have a situation where the judge says to people, quote, ladies in the back. Page 49, I believe, Justice Doherty of the transcript, right? Ladies in the back, please do not continue talking, I'll have quiet, right? But there's no warning about what would happen, and the judge never specifies that Mr. Outlaw was present in the room when that happened or that he was connected to those individuals in the transcript. There's no simple evidence to suggest that contempt would occur, and also, this was also during the recess. Mr. Outlaw further came back to apologize. Similarly, like in Williams v. Williams, you have a statement under a breath. The attorney, did not demonstrate a refusal to acknowledge or doubling down on that comment under his breath. And this court said, look, profanity has no place. There are other sanctions. Maybe the court should have referred him to the disciplinary board. But has to place on the record what occurred such that it is sufficient to justify meeting the elements of criminal contempt.
She did.
She put,
And the sheriff testified as well.
but what the testimony was to is not sufficient for criminal contempt. The testimony here is following the end of the case, he, quote, had his outburst in the room. As a result, he made a statement that was directed towards me. He left the room, came back, and
You wanted her to
apprehended.
go on and say, and it disrupted proceedings, and it satisfied the criteria for criminal.
The conclusion that it disrupted proceedings isn't a fact. That's what the judge decided it did, although there's no evidence that it actually disrupted anything when there is not only a recess occurring, but you have a very short period of time with no statements about Mr. McLean's case being unable to move forward. There was no prejudice or impairment of fairness.
Defendant's statement was not just offensive to her, but offensive to women, offensive to the dignity of court proceedings. She gave a pretty detailed explanation of how, in her view, that statement was contemptuous. Now, I think your best argument is, were the proceedings to be disrupted? Perhaps not.
Well, I am not suggesting that the comment was incredibly offensive and had an offensiveness that might have permeated beyond the judge herself. Nonetheless, right, it is very clear that in a century or more of this court's opinions and even the United States Supreme Court's opinions, offense alone is not the measure of obstruction. Obstruction is not simply how much offense one takes, but it's whether the proceedings or the business will be rendered unfair, such that the jury will be unable to continue with impartially, right, if they've been intimidated or somehow biased, or if the judge has been intimidated or somehow biased in the proceedings. None of that was presented here.
Or if the obstruction is preventing the court from coming back into session
Correct.
after having been recessed.
Yeah.
Absolutely. And all of that is what the law requires, and it did not occur here. No one is trying to suggest that the comments have a place in a courtroom. They
digest your argument. The proceeding was not
the findings of fact. The court does not indicate on June 16th that she was in the middle of making the findings of fact. The court had recessed at that point, and Mr. McLean's transcripts also indicate the findings of fact had been completed. There is no interruption.
Well, the Superior Court said it. The Superior Court's opinion says in the middle of the findings of fact.
I agree. I think they've misstated the
I'm
record.
sorry, Justice
I'm-
Brobson. Hold on,
I'm sorry.
hold on. Justice Brobson.
My only point was it's the Superior Court's opinion that says the trial court was in the middle of the findings of fact.
Okay, and Justice Doherty?
If you make reference to page 5 of the Attorney General's brief, it specifically says that after the judge placed her findings on the record, but before the proceeding concluded, Aplt stood up and yelled the comment. A footnote, it appears the exchange occurred during a portion of the hearing where the stenographer notes, quote unquote, brief recess taken. So I'm asking you, that seems to be in contradiction to the fact that court had recessed and a comment was stated but not part of the record. The record clearly indicates that there was a recess taken that simultaneously was at the time when the judge was addressing the obstruction. So I guess
I disagree with that.
so are you telling me the Office of the Attorney General is misrepresenting the notes of testimony? Or because that's in complete contradiction to your position that the proceeding concluded.
So The record indicates from June 16th, and I'm not sure which notes the page 4 to 6 of the June 16th hearing. First, I will suggest Mr. McLean's hearing indicates that the statement itself very clearly, the findings of fact continued before the recess was taken. There is no interruption in the proceeding indicated there. On the June 16th, page 4 to 6, right? I do not believe, the deputy says.
Where are you reading, sir?
I'm looking for where specifically it would indicate on page 4 to 6. I am not seeing. The judge says on page 6, and was there anything that you heard this gentleman say after I made my decision? The deputy, well, first gentleman got up, made some remarks, walked out. Then this gentleman got up and said the comment. And the court said, oh, the judge, well, I guess that would be me. And that is the extent of the conversation on page 4 to 6.
If you jump to page 103, it should be brief recess was taken, which is reference the
Correct.
time period that Her Honor's order reflects.
Well, the recess is taken on page 103 well after the judge renders every fact and decision in the suppression motion. The suppression motion concludes on page 102. Mr. McLaughlin is asked by the court, who's counsel for Mr. McLean, what the court says to Mr. McLaughlin, what would you like to do? She finished her reciting of the facts. She rules denying the suppression motion, asks Mr. McLaughlin. He says, I know it's 4:30, and I'm reading from page 102 on the McLean transcript at the bottom of that page. What I would like, and I know it's 4:35, Your Honor, so I would need to speak with my client and give him his options in terms of a jury, a waiver, or a potential for a recusal. The court request for recusal would be a jury demand. Mr. McLaughlin understood. Okay, the court, I'll give you 5 minutes. This is, and then parenthetical, brief recess taken. There is no indication that this occurred either on the June 16th hearing transcript in Mr. Outlaw's contempt hearing, nor in Mr. McLean's transcript that there was an interruption to the court's reciting of the facts. And in fact, you have somebody else standing up first to walk out, which would be suggestive that the court was in fact in recess. Nonetheless, right, even if it happened during the court's rendition of the facts, if the court, as the record in Mr. McLean's, and I don't think it did as the record reflects, but even assuming it had, if Mr. Outlaw had stood up during the court's recitation of facts and walked out, if the court, according to that transcript, and doesn't say so, didn't even skip a beat to indicate what happened and the proceedings continued, right? Just because the court had sheriff go and address him or addressed him after the fact does not result in a current and significant obstruction of the proceedings. Right? Just because it's stated doesn't mean the proceedings are obstructed, and that contempt as a criminal conviction, for which my client served 30 days in jail, for which he cannot get back, despite the judge saying she'd parole him at 15, that conviction cannot stand.
The fact is, the sentence, I would agree with you, severe, but that was not appealed, nor is it before us to correct.
I agree with that. That is not appealed.
Surprisingly.
Well, there wouldn't be any benefit by the point it got here to address his sentence. But I would like to just acknowledge and have this, and remember that part of the reason why the actual obstruction element is part of this, and that not only 200 years of text of the statute, but this court and the US Supreme Court's precedent, is because summary contempt is the very rare exception to due process, in which those immediate sanctions are imposed by a court without notice, without trial. In fact, in Moody, we've said even without counsel for the initial contempt determination. Because of that, the action of that immediate sanction And the evidence needs to be clear and it needs to be restrained. It has to obstruct the business and prevent the court. That did not occur here. The contempt conviction in this case is not supported by our law, this court's opinions, U.S. Supreme Court opinion, and I would ask that it be reversed.
Thank you very much.
Thank you.
We'll hear from Mr. Greer.
Good morning, Your Honors. If it still is morning, for my part, I should be exceptionally brief, that although defendant's patently obscene and offensive remark was certainly intolerable and met all other elements, in light of this court's precedent and very specifically the Williams v. Williams case, the Commonwealth felt constrained to conclude that the evidence was insufficient on the obstruction element. I'm happy to answer Your Honor's questions, but otherwise I will just rest on my briefs for the Commonwealth's position.
Well, let me just ask, was your main concern that there were not proceedings in place going on at the time, that there was not obstruction?
No, I don't take as much issue between how the trial court characterized the order of events as defense counsel does. For purposes of our position, we're taking it as it occurred, how the trial court said following the rendering of my decision, characterized it that way at the 616 hearing, 621 hearing, and used the phrase as the judge delivered her determination in her written opinion. But again, there's only a couple lines of text between motion is denied and that brief recess being taken, because Williams is a case where, it's undisputed that a similarly offensive remark directed at a judge occurred right in the middle of litigation. I would have loved to have a distinction to draw, but Williams was even, more clearly in the middle of a proceeding. So just to be clear, I'm not here saying I disagree with it. It must have occurred during that brief recess parenthetical, but either way, I don't find a way of getting around Williams, even if it didn't happen during the brief recess hypothetical. At the earliest, it happened a couple lines of text earlier, under a minute, I'm inferring.
So, counsel, what are you here to say? We don't handle sufficiency cases. We're not an error-correcting court. What does the Philadelphia District Attorney's Office believe constitutes direct criminal contempt?
You have to turn your mic on, Dan. We can't hear you.
NECOAG.
Is that better?
If it's red, yeah.
It's red.
on. Good.
It's like my face, it's red. What does the Philadelphia District Attorney's Office believe constitutes direct criminal contempt? What should a judge do?
Well, so there is the distinction that I don't believe it is between it's either acceptable or contempt. I can only reiterate the definitions this court has given for the element of what is contempt, which is significant disruption, which the name calling in the middle of a proceeding where, again, I'm going back to Williams, this court characterized as a momentary break. It resumed quickly. It encompassed just 3.5 pages of hearing transcript. It was a transient delay. Tracing back to Johnson, the 1976 case was, this court said, interfere.
Counsel, I don't mean to interrupt.
Yeah.
We all read those cases. I thought you might have something to add in terms of what we should write in an opinion.
That the options are not endorsing behavior and summary direct criminal contempt. In Johnson, significantly, there was a footnote explaining what lies in the middle, that, quote, conduct which does not threaten the administration of justice, however, need not be tolerated. The offending party may be directed to cease his activities, and then notably, this is the And then, I mean, essentially every argument I thought of when I was first assigned this case of like, surely this is criminal contempt, has already been disposed of in that Williams case, again, focusing on, regardless of how patently offensive the remark was, that the delay in the proceedings or the disruption to the proceedings was so minimal. If that case did not exist and occur after all these other cases, then I'm sure I would be here saying that this is and must be direct criminal contempt, but that's just not what this court has said in the
You
past.
still have to show us how it obstructed the administration of justice. A crime.
Yes, and if, again, this court had not, so that's where it is well taken, the Attorney General's point about the purpose and goals underlying criminal contempt being that threat to the administration of justice, regardless of the actual disruption. But again, Williams put that hypothetical argument I would have raised to rest.
All right, thank you.
Thank you, Your Honors.
Mr. Belawa, I've mispronounced your name, I fear, but perhaps you could correct me. Would you like to argue for the Commonwealth?
By the way, Madam Chief, I did disclose to counsel, I believe, that Mr. Pilawa formerly worked as an intern and a law clerk to me. Doesn't mean I'll go easy on him, though.
No, but it does mean you know how to pronounce his name.
I do. Pilawa from Beaver County.
That's correct. Other side of the state. Good afternoon, Your Honors. May it please the court. Ricky Bilawa for the Commonwealth, or Attorney General's Office. So I would like this court to imagine for a second if in that brief period after Mr. Minner calls his case, when everybody's coming up here and getting ready and you know, people are quiet for the most part, that Outlaw would have came into this court and did what he did in Judge Covington's courtroom. Outlaw's argument would leave this court powerless to do anything about that.
It's not powerless, Mr. Bilawa. Suppose he did that, we could immediately bar him from the courtroom. We could enter an order he's not permitted to come to this court. So it's not distinction between convicting somebody of a crime and incarcerating them on the one hand, and on the other hand, doing absolutely nothing.
I agree that that's correct. I think there are lesser options here. One of them would be a fine, and I think that the sentence here was unnecessarily long, and if I was a judge, I definitely wouldn't have posed anything close to that. But I think that the contempt power includes much lesser things as well.
This hypothetical, though, these hypotheticals are kind of important because I'll take yours, and if Mr. Outlaw had come in here after Mr. Minner had, in his wonderful professional calming tone, had gotten everybody to relax and we were about ready to come in, but before the bell is rung, Mr. Outlaw comes in and starts screaming. So we're technically not in session, but he's screaming, preventing us from coming into the courtroom. That would be an obstruction of justice. That'd be an obstruction, at least under Williams, a significant interruption of the proceeding, because we can't come in, correct?
But if it's under Outlaw's theory of the case, I think that would just be a momentary break. It would be like a couple.
It could be a prolonged break.
It could
prevent us from actually coming in.
It could.
We can't get in because he's not leaving. They're having a hard time getting him out. He's refusing. That would be an obstruction of the administration of justice.
And I think that even under lesser facts, like when I was given my hypothetical, I was assuming in that momentary break between two cases. So before this case, when Mr. Minner called this case, if Outlaw was on his way out and proceeded to scream what he screamed in Judge Covington's courtroom, under Outlaw's approach, there would be nothing this court could do because he's already on his way out. So ordering him to leave isn't really meaningfully enforcing that in any way. He just gets one free bite to do that, and then I guess gets to go away. And everyone else would seem to have the ability to do the same thing. They would be able to scream whatever they want and then leave.
So what's your argument? What's your best argument here?
Oh, you're ready to go. An obstruction to justice would be something that goes beyond delays in a proceeding. It would include things that diminish the court's authority to enforce rules of decorum. I think that those things matter.
Did you say diminish the court's authority?
Undermine the court's authority to enforce rules of decorum. So I think that everybody knows that what Outlaw did is something you should not do in court. I think it's extremely clear that that's something somebody shouldn't do, and I don't think it would require a warning to know that. And I think that to give everybody one free pass to do that would obstruct the court's ability to.
How did he undermine undermine her authority, at what point could it be questioned that she was the boss?
So there was this brief lapse in the proceeding. When I believe it occurred is when it does note brief recess taken. I don't think it was at the complete conclusion of the hearing. That seems to be the most consistent with the judge's findings. So I think that the judge was still acting in a judicial capacity. She was just saying, okay, counsel, confer with your client quickly and decide whether you want a jury trial, a waiver trial. The judge was still acting as a judge. This wasn't a judge like outside of the courthouse walking away. She was demanding the same level of respect that would happen in that brief break between cases in this court.
To that point, in the transcript from June 21st at the contempt hearing or the contempt sentencing hearing, the judge states, Mr. Outlaw, your actions before the court were simply egregious. You brazenly demonstrated your repudiation of the court's findings pertaining to your friend's sentence, and in essence, it was a flagrant scorning of the court's authority in an attempt to undermine my authority, as well of the goals of the court and what I was seeking to achieve through my determination of the findings on that motion. Your outburst was disrespectful, not just to me as a woman, but to every woman who was present in the courtroom on that day, but to the court as a whole, not just me as a judge, but to the court itself, this room, and to the bench in its entirety. Does that persuade you one way or the other as to whether this was an obstruction?
Yes, I think that that captures exactly what an obstruction is, and I think the phrase obstruction of justice has always meant exactly what she was talking about. This statute was adopted in 1809, and the way that people used words back then were very different than how we use them today, and obstruction to the administration of justice back then always referred to things that were diminishing the court's authority. It wasn't limited.
And I saw that in your brief, and I thought that was an interesting argument. But 4132, or whatever the statutory section, limited the old common law power. And that's what we were saying in Williams when we said judges shouldn't confuse offenses to their sensibilities with obstruction to the administration of justice. Three of us were common pleas judges. We saw a lot of bad behavior. But a judge can't, stand on dignity and respect. And there has to also be a significant disruption of the proceedings. It's not just the judge gets offended and has to it's important for the judge to vindicate his or her authority, but there's another step required to convict somebody of a crime. And that's where the significant disruption comes in. You agree with that?
No, I don't. I agree with parts, but going back to the statute first, I think that the only thing that really changed from the common law was in the presence of the court. Prior to the adoption of the statute, the first Chief Justice of the PA Supreme Court, I believe who it was, held an individual in contempt for libel, so publishing something in a paper. And there was another one, a Passmore case, where that same thing happened. And this statute came in the wake of those things. So the court was really trying to constrain these insults on the court that occur outside of the courthouse. When these things happen in court, people are very clearly seeing that the judge is not being respected. So that was the only phrase that was added.
The court is not being respected. The authority of the bench, the courtroom, the administration of justice as a whole. It's not just this one individual. It's not just this judge. In fact, Mr. Outlaw testifies, he says, I don't even know you that well. Well, it wasn't that it was so personal. It was that she is the judge.
Yeah. And one of the things I think that separates this courtroom from the courtrooms on TV shows is that those rules really matter here. On TV shows, those things are kind of, skirted away because that makes for entertaining TV. But so I think if it's allowed to be weakened, that, this courtroom could become places like that if these rules aren't strictly enforced, maybe not to the same degree that the judge enforced them here, but with some kind of real punishment. And I think the overall suggestion that a reprimand...
Hold off just a moment.
Is that good? Okay. The suggestion that a reprimand would suffice, that really does just give everyone one free attempt to do this. And then...
Not really. Suppose, hypothetically, Outlaw did this disrespectful, disturbing, insulting thing, and was reprimanded or he escaped. Whatever happened with him happened. And then, encouraged by that perhaps, a bunch of other folks did their one-time thing. You could definitely envision that would obstruct the administration of justice, these serial attempts.
Yes.
And each of them might be held in criminal contempt because they did perhaps obstruct the administration of justice, even though perhaps Outlaw did not.
And that was this case also. There were two outbursts that occurred prior to the proceeding. It was not Mr. Outlaw's outburst, but there were two outbursts. And the judge said, please maintain order. There were two prior attempts. And Outlaw's outburst came at the end of those things. So it was saying like, hey, your two prior attempts to maintain order here really don't matter to me. I'm going to do this anyway. And if you're doing it just because it was happened during the testimony, I'm going to wait a couple seconds and then I'm going to have my outburst. So it was really a scorning of the court's authority to try to maintain order in those two prior attempts. It was really an attempt to show that the court's standards, its rules, everything don't matter at all to Outlaw. That's what he was communicating. And that's what the people who had the prior outbursts, everyone else present in the court, would have thought that they could have done the same thing. They did do the same thing, and they got a reprimand. And now they know, oh, I could have actually escalated what I said. And
is there any reason why this judge or any other judge in a similar circumstance couldn't order the courtroom cleared?
The court could order the courtroom cleared, but I don't know if that...
Disruptive people in the room, clear the courtroom. Is that not a remedy?
I think doing that would probably cause the literal obstruction. That would delay whatever proceeding was going on. If you were to clear the courtroom, you're now taking up a substantial amount of time. So what the judge did here was actually continue the proceeding in an attempt to not have a bigger disruption occur. And I don't think courts should have to wait until a proceeding is totally mucked up in order to impose punishment. Like, contempt should be prophylactic. A court should be able to say, things are getting out of hand here, my rules are not being respected, I'm going to hold you in contempt to prevent that from happening, to prevent things from getting any worse.
Thank you, Mr.
Counsel,
Go ahead.
Counsel, do you agree with or I think you must agree, with the Superior Court's truncated holding in this case, that this defendant demonstrated his disrespect for the court and its command of the courtroom, finding that sufficient to constitute obstruction?
Yeah, that's the standard, I believe.
Okay, so if we do that, you would agree we would be changing the law as it currently exists?
I don't believe so. In the Phila case, that was the case where a defendant made a threat to a witness who just testified. It was the end of a proceeding, and the defendant said, I'll be out of prison one day. In that threat, obviously this witness wasn't deterred from testifying. The witness already did testify. And the court's reasoning in that case was, well, if we allow this to happen, witnesses in future proceedings won't come forward because we don't want them to believe that the court is powerless to do anything about threats from them to testify. So I think that kind of broader concern with future proceedings is what contempt has always been concerned with. In the cases that have limited it, they all really dealt with attorney misconduct. They dealt with kind of minor oversteps where an attorney said something like the judge is biased. So in those cases, the court was weighing this idea that attorneys need to be able to advocate zealously against the need to have maintain order in a proceeding. In this case, that kind of balancing doesn't exist. A spectator has a duty to be quiet during a proceeding.
Are there other spectator cases?
Briefly, just because I think in regards to the findings, it's very relevant. It shows that, and I didn't address it in my brief, but Moody shows that a court doesn't need to have evidence of the contempt in order to find someone contempt or make findings, and that contempt is very often something that can't be transcribed. It often deals with individuals fighting or something like that, where a court reporter is going to be typing down everything that happened. And we rely on trial courts to make findings. And in this case, the initial findings that happened on June 16th were truncated, and they were truncated only because Outlaw at that point was conceding contempt. So the judge didn't believe she needed to make further findings at that point. Then there was a habeas motion, and the judge was like, oh, they're actually challenging the sufficiency of the contempt. I need to add additional findings to this record in order to show that there was contempt. And Justice Wecht, I believe your point is true that judges need to have thick skin, but I don't think that judges should become the public's whipping post, and I don't think that courtrooms should become places where the public gets to air their grievances.
Let me ask you, you distinguish Williams, I guess because you're not asking us to overrule Williams, are you?
No.
No, I'm not, and I think there's a
Distinguish Williams on the grounds of the volume of the defendant's statement. So I guess there you're conceding that you're not asking us to criminalize, quote, disrespect, unquote, which is, I think, an important point to remember. But you're saying it's the volume, so I'd be interested in knowing how the standard you want us to articulate would decree what decibel level can amount to criminal contempt.
I don't think it's volume. I think it's what really matters is the fact that other people heard it. That in that case, it was opposing counsel who heard it, and it was the court reporter in Williams. And they had to convey that to the judge. In this case, this was said loud enough that the judge heard it, so clearly other people in the courtroom heard it as well. And it's,
The sheriff heard it.
yeah, the sheriff as well, yes.
Okay, so in Williams, the stenographer heard it, the opposing counsel heard it. In neither case, is there any dispute that the disgusting remark was made? So you seem to be dancing on the head of a pin here to distinguish Williams from this case. I mean, we were quite emphatic in Williams about, disrespect and horrible behavior is not enough. So you're saying that if opposing counsel and stenographer immediately are indicating this remark's been made in open court immediately, that's different from what happened in this case.
I think standing up, making a spectacle of yourself when you say this thing, and what happened before this, where the judge was trying to control the courtroom, I think when you take those things together, it shows that this was a flagrant defiance. That was clearly an attorney who was frustrated and said something under his breath. There were,
Worse, that's an attorney. I mean,
well, of course. Or it could have been a party or whoever said it. I think it's the fact that it was this frustrated grumbling. It wasn't like a clear sign to the court that I don't respect you. It was an attorney who was upset with the way that the case was going. I think probably in that case, the real fault wasn't necessarily obstruction. I think it was probably the intent element. I think it was very weak there, that there was somebody who says something under their breath probably has no intent to instruct. Somebody who stands up in court and directs it directly at the court does have an intent to obstruct and then actually does obstruct.
And there are other corrective measures that can be taken with an attorney for that conduct.
That's correct.
Significant.
Significant ones, yes.
Correct.
And I think most of the cases deal with attorneys because
They do.
that's because significant measures were probably taken and the attorneys wanted to do something about it, whereas normally probably this would have been like a one-day sentence or a $200 fine or something like that. And if that were the case, we probably would not be here today. I think that everybody would understand that something like what Outlaw did would be punishable by those more moderate measures. I think the real issue here is the discretionary aspects of sentence.
what?
Discretionary aspects of the sentence. I think
That's not before us.
it's not before this court yet.
All right, any other questions for Mr. Bulua? Mr. Bulua, I would comment that having interned for Justice Wecht, and clerked, you at least learned one thing, and that was how to respectfully disagree with the good justice.
That is correct.
Well done. Thank you all. Thank you all.
Thank you.
Mr. Minner, we're going to recess for lunch. Don't anybody yell anything. We'll resume at 1:20.
Test 1, 2.
Case, Mr. Minner?
In re Alicia Shepard Smith, representing Ms. Smith, Mr. John Julian, representing Commonwealth, Ms. Alexandra.
In these discretionary appeals, appellant was arrested following an altercation with her neighbors, during which appellant pointed a firearm at them. Responding police officers arrested appellant and seized her firearm and magazine. Appellant was charged with firearms and other offenses, but the charges were dismissed without prejudice, and appellant filed motions for the return of her seized property. The trial court denied the motions. The Superior Court affirmed, and we are asked to address whether the trial court erred in denying the motions, given that appellant demonstrated she lawfully owned the seized property and had no pending criminal charges against her. Good afternoon.
Afternoon. Thank you, Chief Justice. Well, I apologize. My name is John Julian. I'm the attorney for appellant Alicia Shepard Smith. I'm here with my co-counsel, Mr. Jerome Brown.
Welcome.
And if it may please the court, this case is fundamentally about property rights and due process. The Commonwealth has found a way to circumvent the procedural safeguards of the state's statutory forfeiture scheme to deprive my client, Alicia Shepard Smith, of her property rights and her handgun and magazine. Central in this case is a 2018 decision by this court, Commonwealth v. Erlin. In Commonwealth v. Erlin, this court found, absent a statute authorizing it, civil forfeiture of derivative contraband was improper and unconstitutional. Because, and part of that ruling is because Rule 588, which was relied on this case, is a procedural mechanism for the disposition of seized property, but it cannot delineate the substantive rights that a person may possess with respect to that property. The Commonwealth, though, relied on this procedure to deny the return of the handguns and magazines after the motion. Issues 1 and 2 in this matter regarding forfeiture are extremely closely related. The first issue is whether or not this was a forfeiture, and does Erlin therefore bar the forfeiting of the handgun and the magazine in this case? This was denied by the Superior Court because they ruled that this was not a forfeiture because the Commonwealth did not file a forfeiture petition in response to the 588 motion for return of property.
The trial court never actually ordered forfeiture, did it, as such?
They ordered that the property was subject to forfeiture.
Did the court enter an order of forfeiture?
They did not.
So, counsel, Erlin was a petition for return of property regarding 2 magazines, right?
And a handgun, I believe.
You sure about that?
Yes.
I'm curious as to more the due process concerns than really the substantive basis for the argument. Because the Commonwealth has a certain burden on a petition for forfeiture as opposed to the defendant on a petition for return of property, right? We have a shifting burden.
Yes.
So if I'm a defendant and circumstances of your case, your client was found, actually not found anything, the case was null prost, and she was originally charged with, I guess, VUFA, violation of the Uniform Firearms Act, for carrying a gun, and simple assault for allegedly pointing it at her neighbor in a terroristic threats. For whatever reason, Commonwealth withdrew that case. She files a petition for return of property. She has the burden to show that she lawfully owns the gun, right?
Correct.
How does she prove that?
How does she prove that? Well, in this case, it was conceded by the Commonwealth. I mean, typically, they could prove that with a receipt or a, but the Commonwealth, the district attorney in this.
My point is somebody's going to have to testify. She's going to have to testify that it was her gun, was taken from her, it's on a property receipt, and she wants it back. In other words, she's got to prove lawful entitlement. How does she do that with a Fifth Amendment charge potentially hanging over her head? In other words, if she gets up and testifies and she said, I had the gun on the street, isn't she admitting to a violation of the Uniform Firearms Act, in which case the Commonwealth can rebring the charges?
Yes, but the only The only burden that the movement has is lawful possession. I mean, there's many ways that they could show that.
How?
Like I said, a receipt,
Give me one, well,
a purchase, a legal purchase of the gun.
sure, I'm not saying she didn't illegally purchase it. How does she verify that she's the person on that without testimony?
Without, well,
Doesn't she have to authenticate the receipt?
did she? No, but in this matter,
Doesn't she have to? Somebody has to authenticate the document.
I would agree that that is how it should be done, but in this matter before us, the Commonwealth conceded to that immediately in their opening, that it was a lawfully possessed, that it was her weapon and that she had.
Was there a stipulation?
Was there a stipulation? There was not a stipulation.
You say the Commonwealth conceded. That means that's just argument. That's not proof.
Yes, and I mean, proof is one of my issues here, is that.
It's a due process argument. How do you prove it? That's what I'm trying to get at. To use Justice Brobson's terminology, that's the nub of what I'm trying to figure out here. Your client has a burden on a petition for return of property that shows that it's her gun, she's lawfully entitled to possession of return of it. How does she prove it?
I think the trial court found that she was in lawful possession. They said though that their trial court was not going to return it because the trial court said it was derivative contraband.
Correct.
Right.
And the
So there's no.
Commonwealth conceded, so that's, in essence.
I mean,
a
and that's,
stipulation. Can I finish?
Sorry.
The Commonwealth conceded, so isn't that in essence a stipulation?
I don't think it is
It has the same effect.
a stipulation, but it has the effect, I would say, of conceding, and also
The Commonwealth's not arguing here that you didn't prove that she lawfully possessed the firearm.
Correct.
Nobody is contending that at all. Not even the Superior Court questioned your client's satisfaction of the rule, at least the
Correct.
first part of it. The question is, notwithstanding your satisfaction of the first part of the rule, can the Commonwealth indefinitely hold on to something when you have satisfied the first part of the rule?
Yes, that I think is the central issue.
That's the nub.
Yes, the nub. Yes, I would say that is actually the nub of this case is, and central to Erland is when and how the Commonwealth can deprive you. And in this case, from my reading of Allen, where there's only a 30-day, after 30 days, the property title goes to the state, this is your one and only chance to vindicate.
I don't know if that's what Allen said. I think Allen, although I'm not necessarily a fan of it, I think what Allen said is if you want to preserve your ability to file the motion, you have to file it within 30 days. Meaning if you wait past 30 days and file it, Allen seems to suggest that you forfeited your property. But if you file it within 30 days and it's denied, that doesn't mean you can't file it later. So, for example, under Allen, you file it within 30 days, and the Commonwealth comes to the hearing, concedes or you prove or concedes that your lawful ownership. The Commonwealth may say, well, but Your Honor, we are planning to recharge the defendant to refile these charges, and we would ask that you deny the motion to give us an opportunity to refile the charges. Allen would say, you file within 30 days, you're good, but we're going to deny it anyway because the Commonwealth wants to refile charges.
I agree in that scenario that is a possibility.
That's
not the facts of this case. The facts of this case are that the Commonwealth moved to keep this under a theory of derivative contraband and that she was not entitled to the return of the property. And there was no indication that they ever intended to return the property. The statute of limitations, which is part of the Commonwealth's argument, has long since passed. She hasn't received her property. She has no, maybe I'm reading Allen wrong, but at this time, since it's been denied, I don't believe the trial court would have entertained a motion for return of property again.
Can I ask you, would your proposed rule mean that anyone could get derivative contraband back just by showing ownership, mere ownership?
I believe, unless it is enumerated in one of the forfeiture offenses, in a derivative contraband theory, I would say yes, the property must be returned.
What about the problem with ongoing prosecutions?
Well, again, in the instant case, there isn't now. There could have been at the time, but they didn't move under that. I believe that there is a.
You say they didn't move, they didn't oppose on that basis.
Yeah, their reasoning for opposing the motion was it was derivative contraband. They never presented, even in a good faith manner, that they might, let alone would, refile charges.
Fair enough. I'm just sort of walking through this because I'm trying to think
Yes.
what the implications of your proposed rule would be, not just for your case, but
Of course.
trying to think of Rule 588, whether that needs to be changed.
Yeah, I think it's likely if, some showing that they intended to actually refile the charges, this court could make a rule that's acceptable. I mean,
Well,
until
we do have a rule, we have Rule 600. And so if a prosecutor does what they did here, and in response to a return of property, came in and said, we're going to refile the charges, Rule 600, I think, gives them, 360-some days to refile?
Yes.
Not the statute of limitations, I think that's wrong, but then the trial court judge may, based on the representation of the district attorney's office, say, okay, there's still a question here as to whether this might be derivative contraband. They plan to refile charges. I'm going to deny your motion for the time being and see if they refile their charges.
But there doesn't have to be an active criminal case for there to be a Rule 588 situation, right? I mean,
correct. Yeah, I mean,
there seems to be an issue here with the rule, at least as I read this case.
yes, there doesn't have to be an active criminal case. Non-criminal defendants, if someone I live with was charged with a crime and their property was taken, or my property was taken as part of that raid or seizure, I could file independently. So there does not have to be a criminal case. But in this case, there was, and it was disposed of, and the Commonwealth's theory at the hearing and until this appeal was that it was derivative contraband and that my client is not entitled to the return of that property. Ever. I mean, I don't see it any other way. I mean, ever. I mean, they've given no inclination. They could have mooted this case by returning the gun 2 years ago when the Superior Court appeal was filed.
I mean, it seems like there ought to be some time period, but I don't know what it is, but that's why the Criminal Rules Committee makes the big bucks.
Yes. I mean, I think the relevant time period, if the theory was a pending criminal case, would be a Rule 600 time frame, which...
Julian, let me ask you this.
Yes.
What's your position? Are you in agreement that the Commonwealth's permitted to retain the property while criminal charges are pending? Or in this particular case, criminal charges were dismissed, but let's say they had an opportunity to reconsider refiling those charges?
I think they could, with a certain factual showing at the motion for return of property. Something along the lines of the property is actually evidence in the case, and that it's something that they need or would utilize, and that they have, like I said, some good faith that they may refile the case.
So is the nub of this case the Rule 588's lack of a time period, or I guess what I'm trying to say is, here we have a case in which an individual was arrested, charges were dismissed. The Commonwealth is in possession of the lawful property of your client. She would be required under 588 to file a motion for return of property, which would require her to offer evidence of a preponderance standard that she is in lawful possession or should be. Despite the fact, as Justice McCaffrey said, you could be invoking Fifth Amendment issues because the Commonwealth still has that right to prosecute you. So it appears that this court, are you asking this court to refer this to our Rules Committee to indicate that a return of property should only be filed after 30 days after the discharge of a case, thus causing the Commonwealth to make a decision within 30 days after withdrawal? I don't know. I'm trying to find. It seems we're in a bindery for your client.
Well, for my client, again, I think in a case, again, where they're saying they need to retain this for evidence, it could make a difference. But in my case, that's not what they claimed. And they didn't refile the case, I should add. But I don't think the issue per se is the lack of time. I think, this court could make a rule that after the 30 days, it could be stayed until the pendency of a refiling or a Rule 600 motion. It could be something along that. But like I said, the way I read Allen, and maybe the court reads it different, is that after 30 days, it's decided.
You followed Allen. The rule doesn't say 30 days. Allen said 30 days.
Correct.
And you did exactly what you were required to do under Allen. The only exception the rule creates is for derivative contraband, which to me suggests the rule was written in you have to show that you lawfully possess, not lawfully used, that you lawfully possessed, meaning you weren't a person prohibited from possessing a weapon.
Yes.
You lawfully possessed. You had whatever licenses you needed to possess a weapon in Philadelphia or whatever. And then once you prove that, the rule says the order has to be granted, the motion should be granted, unless the Commonwealth establishes that it's derivative contraband. And the way they have to do that is through a civil forfeiture statute.
Or through providing testimony at the underlying hearing. That's where I was getting at.
Well,
the only way you can prove derivative contraband in this circumstance is if they had the neighbor come in and testify she pointed her lawfully owned and possessed firearm at me and threatened me. That's the basis for an underlying simple assault or reckless endangerment or terroristic threats conviction. In this circumstance, where the Commonwealth withdraws it, here's my issue. And I've done hundreds of these. I was in the DA's office. I was in private practice. I sat in trial. Traditionally, the Commonwealth never files a petition for return of property unless they can prove it is, quote, derivative contraband. In this case, it's kind of the exception to the rule. She lawfully possessed a gun. The only way they can prove that it was derivative contraband is if a lawfully possessed gun was used in the commission of some type of offense or crime. Would you agree with that statement?
that would prove, yes, that would prove that it was derivative contraband.
Now, I'm sure you've done these cases. The only way that happens is if the Commonwealth can call that witness in either at the trial or at the petition for return of property hearing to testify. My issue is, when I say due process, my issue is with this loosey-goosey, the Commonwealth introduced a 49. Well, that's a hearsay statement. Objection doesn't come in.
Yes.
All right?
I absolutely,
So if the Commonwealth doesn't provide evidence that it's derivative contraband in opposition to your petition for return of property, the response should be motion granted.
I agree 100%. That's my issue number 3, that there wasn't actually evidence heard at this case. There was materials sent, I believe, as far as I can tell, ex parte to the...
That's, again, the nub, because it always happens that way, because the Commonwealth's going to stand up with the 49 or the 48 and say, she pointed a gun at somebody else, therefore the gun's derivative contraband. Objection, that's hearsay, Your Honor. Motion to strike granted. Anything else from the Commonwealth, any live testimony? No. Your motion's granted.
Yes.
Once you prove it's lawful, all right?
Yes.
These things usually happen in the context of police officers sees a bag of crack cocaine and $4,200. Nobody's going to come in and say the crack and the $4,200 were mine, right?
Correct.
Petition for return of property, petition for forfeiture granted, that $4,200 goes into the forfeiture fund.
Yes. I mean, I completely agree, but I do believe that, personally, that the first 2 issues about forfeiture are actually dispositive in this case. But I agree the evidentiary burden was also not met, and that the proper way to do these hearings is via calling witnesses and producing authenticated, admissible evidence in some manner, which in this case would be calling the complaining witnesses, which was not done.
I think what you're asking us to say, to answer Justice Weck's question, is you want us to say that without an underlying conviction or proof of a derivative contraband or the fact that it's contraband of a derivative nature, the Commonwealth has to give back the property because there's no statutory basis to retain it.
That is part of what I would like you to say, but
anything else?
Yes, I would like you to actually say that the derivative contraband in a process, in a 588 motion, is either what I've been deeming a de facto forfeiture, or when the Commonwealth decides that's the procedure, that's the logic that they want to move under in the 588 motion, that it should convert, they should file a forfeiture petition in that matter. And that not doing so is improper. Correct. Or we could keep the procedure similar to the same and extend the logic of Erland to this case, which is about, and I believe what this court was concerned about was property rights and the permanent deprivation of them. Yes, that is my position. I agree that is, as far as rulemaking goes, that's the easiest outcome and a correct outcome.
Sir, at the hearing on July the 19th, your client testified.
Yes.
Correct. Would it have been sufficient to meet the Commonwealth's burden of proof for the court to consider her testimony?
To consider the testimony as proof for the Commonwealth. I believe without some countervailing evidence, it was an abuse of discretion to say that the self-defense portion of her testimony was not credible. There's nothing, you know, I wasn't there, I didn't hear her tone, but there's nothing in the record that counteracts what she says. I mean, it's uncontested testimony.
Counsel, what, is there a, I mean, our rule actually says that the property is to be forfeited. Like, our rule says that unless the trial court finds that it's contraband, in which case it will be forfeited, right?
I believe it says may. Like,
well, okay, may. But
yes, and my point is that was my point of saying
but
that.
in the absence of a conviction or a civil forfeiture statute, we can't pass a rule that says all contraband is forfeited.
I 100% agree that that needs to be done by the statute. The court produces procedural rules that handle the administrative justice, but our substantive rights are defined by the legislator.
Even if the district attorney had presented some evidence, not beyond a reasonable doubt, but some preponderance of the evidence as if it was a civil standard, that she brandished a weapon in a threatening manner that could lead to new charges that might result in her conviction, there's still no way to get a forfeiture either in our common law or in statutory law, correct?
Yes, I agree. Yes. They would have to, the motion for return of property, if they wanted to keep it for the time being, like towards the end of the prosecution, they would have to have some other showing. Like I said, a showing that they intend to refile charges quickly, or, you know, it's, you know, crucial. It doesn't have to be crucial, but it is actually evidence. There isn't even, truly, again, there's not even evidence that it is evidence that the guns would be used or are needed for the prosecution. So yes, as the court, you know, I agree with a lot of what the court has said, and I believe that this is either, like I said, a forfeiture, and when the Commonwealth moves in this manner, it should be deemed a forfeiture proceeding, or it should be a de facto forfeiture, and that logic under Erland should apply to this case. And if for some reason I haven't met my burden of showing that to you, I also agree with Justice McCafferty that there needs to be proper evidence at these hearings. There needs to be witnesses. There needs to be, you know, question and asking testimony. It needs to be submitted to cross-examination. And I would add that that is especially important because, I mean, I've been in that courtroom. Maybe if there's 60 cases on the list that day, 3 people have an attorney. These are largely pro se litigants from my experience. And I'm not saying that that's the truth, but when there's no, when there's no attorney involved about a substantive right, like your right to property, it really is ripe for abuse. And we've seen the forfeiture statutes abused in that way, both in this city, in this state, and throughout the country. And I think that Erland was probably largely concerned about that, and I think you should, like I said, either extend Erland or say that this should be in the future a forfeiture proceeding, and that the property, but either way, the property should be returned to my client in this manner because she was a lawful possessor of it, and whether it was derivative contraband or not, the Commonwealth does not have a right to retain that property indefinitely. And if the court has no more questions, I would concede my time.
You have no time left to concede. You have no time. All right, thank you, Mr. Julian.
Thank you.
Let's hear from Attorney Amato.
Good afternoon, Your Honors. May it please the Court, my name is Alexandra Amato, and I'm here on behalf of the Commonwealth. Unless I'm misunderstanding what I just heard, it seems that the best place to start is talking about the difference between the denial of a Rule 588 and forfeiture. When forfeiture is issued, there are no more property rights. It is all forfeited, but when 588 is denied, the Commonwealth is merely the custodian. There are other avenues that I do believe people take to get their property back.
What are they?
So what I have been told, I have not done any of them, but from talking to other colleagues, it seems that the there are two most common practices. One is to write to, I guess, the Sheriff's Department or the Police Commissioner and request property back. That doesn't seem to have like a very in-depth process, but that gets sent down through the channels, and some people do get their property back that way. Another, that is not something I can speak to, Your Honor. I'm sorry, excuse me.
Let's flesh this out. So in this particular case,
yes,
defendant was arrested, charged with the crime, property confiscated, charges dismissed.
Yes.
The property is in the possession of the Commonwealth.
Yes. As a custodian.
As the custodian. So if I were to, as a sitting judge, if I were to issue an order for the return of that property sua sponte, because the judge or the lawyer wrote me, how is that any different than writing a sheriff? And where does the sheriff have that authority to release evidence?
Again, this is not a procedure that I am personally familiar with. Perhaps that is just what I've been told, that other attorneys in my office who do the Rule 588 hearings have seen defendants, well, sorry, not defendants, people that have property interest do as an alternative method to get their property returned to them.
What if the sheriff says no?
I think it could be in either case. I'm not suggesting that that is, I'm suggesting that that may have happened, and that is what I've heard when talking to other people that.
Why don't we stick with what actually did happen?
That works for me.
Instead of talking about what maybe possibly could have eventually happened. On what legal basis is the Commonwealth entitled to be the custodian of somebody else's property? Particularly, let me follow my own advice. What is your legal basis for being the custodian of this person's gun? What legal authority do you have?
Before the statute of limitations was up, the Commonwealth had, the state and federal constitutions permit the Commonwealth to hold evidence of a crime. I can't say that the Commonwealth has an interest in pursuing this crime as the statute of limitations is up. There's nothing that the Commonwealth.
Why haven't you given the gun back?
There is no procedure in place for the Commonwealth to sua sponte give property back.
Right, are you serious? Like, I'm not trying to be glib here, but why is there need to be a procedure for the government to give back people's property that you're not lawfully holding?
I think it would be onersome to the Commonwealth to continually do that. That is why this rule exists for people that are aggrieved by these search and seizure procedures.
Why wouldn't the Commonwealth just concede the motion then?
At the time the motion was filed, the statute of limitations was not up.
But you didn't assert that. And this really, I mean, you raised, I say you, the Commonwealth, raised this issue about we could refile charges, not when the motion was filed. When the motion was filed, you argued derivative contraband without any record, without any citation to a statute, without any common law principle to support retaining the property or forfeiting it under the rule. It's only later on, almost after, even after the time period under Rule 600 had ran, that you started arguing that you have 5 years or 10 years to file charges, which is blatantly not true. Which is blatantly not true. You had 360, at best under Rule 600, you had 364 days or something like that, right?
I believe there is case law where if the Commonwealth is duly diligent, the time to refile does not count against them. So I would push back on that hard number, but I believe that.
When did you first raise the inability to? When did you first raise that you were going to potentially refile charges?
We raised it in the brief here that was potentially an option at the time. I would say that Rule 588 does not require the Commonwealth to, it just requires us to prove that it was derivative contraband. There's nothing in the rule that says that the Commonwealth needs.
You didn't prove that it was derivative contraband. You argued it was derivative contraband, but you didn't prove it was derivative contraband.
There is a lower evidentiary threshold for these kinds. I do believe there is one line in which the judge herself moved the paperwork that our attorney gave to her into the record.
It didn't indicate, I saw no motion to admit nor a ruling admitting evidence. It seemed pretty sloppy.
Sorry, would you like me to, sorry, one second. I do have that highlighted.
Evidence, so that's why you.
On page 19, the court says, I do want to make part of the record the police report and everything the Commonwealth sent to me, which is sent on every case as part of the record. I will say that Ms. Shepard-Smith testified that she pointed a loaded gun at her neighbors. That is clearly evidence that, by a preponderance of the evidence, that the gun was used in an unlawful manner.
How is that alone evidence it was used in an unlawful manner? Maybe the neighbor was threatening her.
The judge did not believe her argument that she was defending herself.
Okay, so let's assume you're right.
Okay.
Let's assume you proved that it was contraband. What statute allows you to forfeit it in the absence of a criminal conviction?
There is none, but this isn't forfeiture. This was.
The rule says forfeiture.
It says the court may grant forfeiture. The court did not grant forfeiture. There was no order for forfeiture signed. We did not request forfeiture.
But then the rule becomes an exception to everything else that we have. It's an exception to civil forfeiture statutes. It's an exception to our rules that say you cannot have criminal forfeiture in an absence of a conviction. What you're saying is all the Commonwealth has to prove in a motion to return property, even though there are no pending criminal charges, is a lower evidentiary burden of the wrongful use of the property, and then it can hold on to it indefinitely.
I believe we are saying in this case specifically, the Commonwealth no longer has an interest in this property because it cannot pursue charges related to it.
So you could moot this case tomorrow by handing them the gun, and we'll get a notification that the case is moot and we don't need to decide it.
Again, I don't know the procedure specifically for how the return of property would work, but I guess.
I don't understand why there needs to be a procedure. You're conceding you have no lawful right to hold this weapon. You're conceding it today. We have no basis to hold this weapon.
And you have no interest in it.
And you have no interest in holding it. I don't understand why you're standing on ceremony. I mean, these are people who largely are unrepresented, whose property has been taken by the government. And they come back and they follow our rule. And good for this woman, she followed Allen, which I think is of questionable analysis, but nonetheless our precedent, and filed within 30 days. And you presented no evidence, and you argued it was derivative contraband. You can't cite a statute. You can't cite a law that says you can hold derivative contraband indefinitely. And you come up with this theory of refiling charges up here, but you have now conceded that you're never going to refile charges, but you still refuse to give the gun back because there's not a rule or a procedure to give somebody back their property.
I mean, our position isn't that there's no mechanism. Our position is that if she filed the Rule 588, Allen doesn't forbid a refiling.
Wait, say that again?
Sorry, I may not have explained that very well. Our position is that she did everything right under Allen. She filed within 30 days. Allen does not prohibit her from filing a subsequent motion for return of property.
Why should she have to?
That is the rule as it stands. I think the Commonwealth is worried that it could open itself up to sua sponte having to return thousands of
What's wrong with
property.
that? We're back to the original premise. You're the government.
Yes.
Tell me what right you have to confiscate property from an individual with no basis other than, oh, we may arrest you.
Well, we did arrest her, and she went to a preliminary hearing in this case.
It was discharged.
It was
They're
yes.
dismissed. Therefore, there are no criminal charges pending.
No, it was dismissed because the complainant didn't appear. It wasn't dismissed for something the Commonwealth did inappropriately or that we didn't want to pursue.
So at that dismissal, did the Commonwealth have criminal charges pending against his client?
At the dismissal of the Rule 588 hearing? Is that what you're asking?
No, at the dismissal of the criminal case. CWFTA, NFT, no further continuance, case discharge. Happens every day in our courthouse.
It was dismissed without prejudice, so the Commonwealth could have refiled.
Could have.
Yes.
But did not.
Did not. You're
Therefore,
absolutely
as we sat there that day, there were no criminal charges against his client.
correct.
But the Commonwealth felt compelled to keep confiscating evidence, alleged property, for no reason other than we're contemplating possibly, maybe, it depends if we want to file recharges. We want to refile charges. That's what you're
Yes,
telling
but
us.
it would be evidence of a crime. The Commonwealth is perfectly within its rights to hold on.
No, see, that's the difference. It's not evidence of a crime because you haven't charged a crime. It's evidence of a possible crime that you may charge. And the question is, does our Constitution tolerate holding, keeping somebody's property while, in this situation where you've already charged them and withdrawn the charges, and then turn around and say, but Your Honor, we can't prove as a matter of beyond a reasonable doubt that it's derivative contraband. We can't cite a statute for civil forfeiture, but we want you to just take our word for it that we might possibly file charges, and therefore we're going to deprive someone of their property. That's what, and that's not even what you did here. The Commonwealth didn't say we want to keep the evidence because we're going to file charges, but I'm giving you the benefit of the doubt. I just don't see any, you haven't cited a statute, you haven't cited a rule, you haven't cited any opinion from this court or any other court that basically says the Commonwealth can hold evidence indefinitely under these circumstances. Or not even evidence, because it's not even evidence. Can hold someone's property indefinitely while we try to figure out if we might someday do something.
I would just push back that it doesn't seem like this rule is not letting that occur, and that might be an issue with the rule itself, but there's nothing in the rule that says this can't occur. Again, it is not forfeiture.
So
The-
your
Why isn't it forfeiture? You could keep that gun forever. I mean, in fact, you have kept the gun for no reason.
For 4
Why
years.
isn't that forfeiture? Why isn't that, as your opposing counsel referred to it, as a de facto forfeiture?
Because she still has rights in the gun. It has not escheated to the state. She can file a civil action to retrieve that gun. She could file again.
She did. It was called a motion for return of property.
Yes, but she could also sue the state for return of that property or the value in another channel.
These are unrepresented people. These are unrepresented people who have no right to counsel for a return of property.
Yes.
You're imposing an amazingly high burden on somebody. Basically, your rule is the government gets to keep somebody's property without lawful justification until they hire a lawyer and bring a 1983 action and declaratory judgment or mandamus ordering the return of property. That's your rule that you're asking for.
Or you just say, do you believe in common law forfeiture? What you're arguing is common law forfeiture. A judge's denial sua sponte means forfeiture. We don't have that in Pennsylvania. So tell me why we should. Or tell me what happened in Erlin that we should reverse, because we specifically said there is no common law forfeiture. I wrote it in a CO to Ireland.
Yes. One moment, if you don't mind. I mean, my understanding of common law forfeiture is that a conviction has to occur. Obviously, that did not happen in this case, so I think my understanding of common law forfeiture is that historically a conviction had to occur. Again, this feels a little bit beyond the scope of this case, but from my limited research to prepare, a conviction would have had to occur.
You're sort of close.
Okay.
We eliminated common law forfeiture
Yes.
In the sense that it didn't require a criminal conviction. And
Or
now,
a statute.
right? But well, civil forfeiture definitely requires a statute. There's no such thing as common law civil forfeiture.
Correct.
Right? So you don't have a statute, you concede.
Yes.
You don't have a conviction, you concede. Your dispute is we haven't forfeited it. She still has rights, although she doesn't have a right to have it, because we are the custodian for some indefinite period of time until she hires a lawyer and files a lawsuit.
Or files a 588 motion for return of property, which Allen does not bar, in which case, again, the Commonwealth has no interest in this property.
So she needs to pay a lawyer or do it by herself again to file another motion, even though this motion may have been improperly denied. Because you didn't prove it was contraband, forfeitable without a conviction under under some statute.
Again, I would say Erlin doesn't apply because there's no holding that 588 and a dismissal of 588 and forfeiture are the same thing. There's a lot of case law that says that they're quite different, and one doesn't necessarily lead to the other. So again, I don't believe Erlin applies, and I don't believe we needed a statute in this case.
Motto, I think we're going to sort this out. May I ask, how long have you been with the Philadelphia DA's office?
I think it's over 3 years now, a little bit.
And is this your first argument before our court?
Yes.
Well, you've done a very nice job on a
Thank you.
difficult issue that they sent you here with.
I appreciate it.
So thank you both.
Thank you.
Sorry.
Commonwealth of Pennsylvania versus Quadier Steadly, representing Mr. Steadly, Ms. Catherine Munns, representing the Commonwealth, Mr. Alexander Aplts.
Well, the crowd is thinning. Okay, in this discretionary appeal, appellant was pulled over by police for having illegally tinted windows in his car. After the police officer discovered 2 outstanding bench warrants on a police database, appellant was arrested, but only after a struggle. Appellant was charged with and convicted of resisting arrest. We are asked to determine whether a resisting arrest conviction may be upheld where the underlying arrest was based solely on outstanding bench warrants and the Commonwealth presented no evidence specifically establishing the warrant's validity. Good afternoon.
Good afternoon, Your Honors. May it please the Court, my name is Catherine Munns, and I represent Mr. Steadly. I am from the Defender Association.
Okay, would you pull the mic up a little bit?
Yes, you'll have to forgive me. I'm getting over being sick, so I'm still getting a little bit breathless, but it will at least keep me talking slowly.
Take your time, drink some water.
And just to remind everyone, if you could speak into your microphone, I have one hearing aid in and then one that tells me what you're saying into the microphone. It is not the existence of a warrant which renders an arrest lawful, it is the validity of the warrant. The lawfulness of an arrest is an element of the offense of resisting arrest. And when a defendant is arrested pursuant to a warrant, that warrant must be valid in order for the arrest to be lawful. Arrest must be based on probable cause in order to be lawful. Now, when a warrantless arrest is made, probable cause is determined at the time of the arrest based on the observations of the officer, what they see, what they believe, etc. However, when a warrant is involved, the probable cause determination is made at the time of the issuance of the warrant. So probable cause to believe a warrant exists is not the same as the probable cause supporting the warrant. Now, in Biagini and Jackson, this court...
Would you say that again? I want to make sure I heard you correctly.
Yes. Probable cause to believe a warrant exists is not enough to establish that a warrant itself is supported by probable cause.
But is a good faith belief that the warrant exists sufficient to create probable cause?
No, Your Honor. And I would point to actually a number of cases discussing the good faith doctrine. It's the one agreement.
I shouldn't have said good faith. Maybe it's more reasonable.
You got me excited. I was going to talk about the good faith doctrine.
You can talk about both, but I think the correct statement would have been a reasonable belief.
Yeah, you know, it's interesting. The way that the lower courts, and to some extent the Commonwealth, present this case is by looking at the officer's actions and saying, well, didn't he do what he was supposed to do? He checked, and someone said this over police radio. What else should he do? And
I apologize. Are you making this a sufficiency challenge or an error review? And if so, why are we here?
Well, it is an underlying sufficiency issue, but the issue that the warrant itself need not be established as valid in order to meet that burden is the error that I'm asking this court, well, not the error, but I'm asking this court to find that it is not simply the existence of a warrant, but the validity of the warrant that matters.
So if an officer, so are you saying that because the officer, based upon a stop, obtains information that a valid warrant exists based upon his speaking to the appropriate contacts in the police department or going through NCIC, his good faith effort to stop that car and arrest him is what?
Well, Your Honor, the only part of that statement I would take exception with is the word valid. What we have here...
Valid to him, that's all he knows. The question...
It makes it reasonable, right?
Right. The issue here is what did the officer know to make this a lawful arrest? Not something that can withstand reasonable doubt. There's a different standard. But we're indicating, so at what point, based upon your logic, does an officer is going to have to do what? Proceed to obtaining discovery for a potential arrest while his safety's at risk?
Oh, no, Your Honor. I would simply say that this isn't about whether the officer did the right thing. This is about whether the Commonwealth at trial did the right thing. Because an officer, in the moment, he's relying on what he hears. And in fact, the collective knowledge doctrine says officers can rely on what they hear over police radio. This is not about whether the officer should have done more or was mistaken. But as this court has stated, and as the U.S. Supreme Court has stated, when an officer does rely on something over police radio, when we come into court, the Commonwealth has to then establish that what they relied on established probable cause. And so there is a line of cases suggesting that entries in NCIC relating to warrants are sufficient, and they're a little bit varied in that some of them actually on their facts have more information to support the existence of a valid warrant than others.
To that extent, isn't there a vast difference between an arrest warrant versus a bench warrant, in that an arrest warrant seems to be more of the type that you were describing at the beginning of your presentation, where an officer goes to a magistrate and swears before the magistrate the facts that would support his cause for the arrest of the individual, and then the facts are confined to the four corners of the warrant, whereas in a bench warrant is more of an order from the court. So if you're, in my mind at least, and I could be wrong, if you're questioning the authority or the propriety of a bench warrant, an order of the court, isn't that something that's established as a matter of the law of the case?
Well, if the Commonwealth presented evidence that it was done correctly and that it was supported by probable cause, then
Well,
it
if
might
not,
be
if it wasn't done correctly, it's on the trial judge that issued the bench warrant, correct?
Well, if the warrant, any warrant, I mean, the Constitution doesn't say only arrest warrants. It says warrants shall not issue without probable cause. And so I would suggest that even if it is a bench warrant, it still must be established by probable cause. But I actually, it's interesting, when we think of bench warrants, what we think of is someone is in court, they get served, you know, they're supposed to come back. At the next hearing, we're all there. And, you know, the crier stands up and calls out, the person's not there. They had service, bench warrant is issued. This is what we think of as a typical bench warrant. But bench warrants, the term bench warrant, actually, they're issued in a lot of situations. They could be issued if somebody wasn't complying with the terms of release. They can be issued if someone pays a ticket but doesn't pay enough, right? And so in that case, the bench warrant isn't for an arrest. The bench warrant actually allows them the opportunity to pay the officer. I actually was surprised when I was reading that statute, but it's called a bench warrant. They can pay the officer, get a ticket, and then clear the case, and only if they can't pay do they get to be arrested. And so a bench warrant can mean a lot of things. And so the words bench warrant, I would say, aren't enough. There must be something more. I'm sorry, Justice Wecht, would you mind speaking into your microphone?
Counsel, the nub of it, to use a Brobsonianism, is that the trial judge sustained your objection, your best evidence objection. There was no printout of the bench warrant. There was no. This is not about the officer's probable cause to believe the warrant existed. Nobody's challenging that. It's as I take it, you're saying that there was no valid warrant established in court, so that's a missing piece of the arrest being lawful. Isn't that the point?
That's absolutely correct. It's really interesting whenever you look at what little evidence of a warrant there is in this case. It's shockingly little. The things that we don't know outweigh the things that we do. We don't know what the case was for. We don't know what kind of bench warrant it was.
Does that matter? Does it matter what kind of case it was?
Well, actually it does, because if it's for a summary, then he might have just been required to pay some money rather than just simply be taken into custody. You know, and in this case...
Counsel, this case generated probably the most spirited debate in my chambers of any case that I've had since I came on this court.
I'm happy to hear that.
I know, it's very interesting, and you're getting to this layer argument. I understand that the Commonwealth may have messed up here by doing the bare minimum, which would have been all they had to do was produce the warrant and show the warrant was there. But are you taking it to another level? Let's say the police officer looks on the computer system, confirms with someone on the radio, yep, there is a warrant out for this person, a bench warrant out for this person's arrest, and they arrest them. And let's say the Commonwealth did put the warrant on and said, yep, police officer here's the warrant, there was a valid arrest warrant, or there's an arrest warrant out for this person's arrest. Police officer effected the arrest, and the person resisted and beat the crap out of the police officer. Say all that happened. Are you saying that you then get to go to another layer as defense counsel on the resisting arrest charge and actually try to fight the underlying facts that resulted into the issuance of the bench warrant? Because that sort of takes it to another level. If all you're saying is, look, the Commonwealth just needs to produce the bench warrant, that's one thing. If you're saying we now will turn this into a litigation over the underpinning facts or procedure that led to the issuance of the bench warrant, that takes it to another level, doesn't it?
You know, I would say this in some ways could parallel Four Corners. I'm not saying that's what this is, but I'm just using this as an example, right? Say police obtain a warrant. It's based on what they believe is probable cause. We get the copy of this warrant, which is, again, more than has been done in this case. We get a copy of this warrant, and we're able to say, you know what? They weren't specific enough. It's whatever reason, we don't believe it supports probable cause. We can go into the court and say, you know what? This search should not have been done. This warrant was insufficient. And there's plenty of precedent for that. It isn't...
on a resisting arrest charge.
Well, I'm just sort of using this as an analogy, right?
Well, but
because we can
I'm concerned
challenge...
about resisting arrest charges because that's what we're dealing with here is police officers in the field have no idea what the underlying legal or factual basis of the warrant is. They're duty bound when a court issues an order calling for somebody's arrest to effect the arrest. So I can understand sort of a line in the sand being, in these types of cases, the Commonwealth must at a minimum present the warrant. I am a little concerned about going to the next layer and saying, and we get to now challenge the warrant, in which case officers may say, hey, I'm not going to risk getting clobbered out here to do these bench warrants if these people are going to turn around and get away with it.
Well, if an officer believes that they're in good faith that there is a warrant, I think that this is very good parallel to the collective knowledge doctrine. We're not arguing that the officer did anything wrong here. And it's also, I don't know that it would necessarily blow back on the officer, because in all of these cases in which there's an invalid warrant, maybe it's expired, maybe it's already been served, maybe it wasn't supported by probable cause, no one is saying this officer should have figured that out.
Well, that's
not
kind
the
of cold comfort for an officer who is probably now out on heart and lung.
Well, but if the individual did commit another offense, then we'd be having a different conversation. This is really just about where there's only resisting arrest.
So can I follow up? I understand what you're not asking. Can you tell me what the Philadelphia Public Defender's Office is asking? In other words, what do you feel is the proper procedure under these circumstances where a police officer pulls somebody over, looks at his NCIC, PCIC, and sees an arrest warrant for the person he just pulled over? Does he have to wait there, physically come down to the 1301 Filbert Street, see if they can find a copy of the actual clerk of quarter sessions notation of the bench warrant, maybe bring in the judge that called him? What does the public defenders of Philadelphia think is required under these circumstances to justify the arrest of Mr. Steadly?
A valid warrant. And the only argument
how does that police officer obtain it or verify the validity of a warrant at the time of the arrest such to insulate himself in the event that he gets punched in the face or assaulted otherwise? Or if that's not what we're talking about, what does the Commonwealth, through the District Attorney's Office of Philadelphia, have to present in court to show that? Does he have to call the clerk of quarter sessions and say, Mr. McCaffrey, you were the clerk of quarter session in Judge Doherty's courtroom on April 15th, 2022. Is this your notation? Yes, it is. Was a bench warrant issued? Yes, it was. What was the bench warrant for? Mr. Steadly failed to appear for a court hearing that day.
Yeah, I would say that we're not asking this court to say there's a specific set of circumstances that must always happen when there's a warrant involved. What we are asking is that this court require that when it comes to trial, we're not talking about whether the officer did anything wrong in this.
I understand. You made that clear.
Right. When it comes to trial, that the Commonwealth should present evidence of its validity. Now, that can happen in a lot of different ways, and there's so many situations that bench warrants come up. I would hesitate to say there was one way it could be done. It could be out of county, it can be out of court, it can be an arrest warrant, a bench warrant. There's all different kinds of ways. But it's really not
It's an out-of-county warrant from Beaver County. What happens?
a bench warrant from Beaver County. Well, a good start would be a copy of the warrant itself. And look, you know, one really, really simple way to do this, if they know what the bench warrant was for, get a copy of the bench warrant and a copy of the docket.
Right, that's, yeah, please go ahead.
The fact that this is an automobile,
Sorry, I can't tell directional at all.
does the fact that this is an automobile play any role? Because you're saying if it was from Beaver County, that a good start would be to obtain the warrant from Beaver County. Are you saying at trial?
Oh, yes, yes, of course, Your Honor. Thank you for clarifying. Only, we're just talking about at trial. Yes. You know, because it isn't the existence of a warrant that creates probable cause, it's validity. And in this case, the Commonwealth did zero. They put an officer on who said repeatedly, I didn't make any effort to try to figure this out. I don't know.
I have to stop you there because I'm not sure I agree with you. Isn't the probable cause going to be based on the reasonable position that the officer took based on the information that he received that the warrants were valid? Isn't it based on what was reasonable for an officer to believe under those circumstances?
Well, I would say that because it's a warrant, when we're evaluating probable cause, we look at the time of the issuance of the warrant, not the officer who finds evidence of the warrant.
But the resisting arrest occurred at the time the officer was pursuing him. I mean, if we're judging whether the resisting arrest conviction falls, it seems to me that we have to focus on that moment. But maybe I'm misunderstanding.
Can I interpose there, Chief Counsel? I think the point you're trying to convey here, and maybe this is not responsive to the Chief's point, is that you're not asking us to focus on the policing interaction. It's not a question of what this guy did. What's his name? Steadly. It's about when it comes to court, a key component of resisting arrest is that there was a lawful arrest, and a component of that is the existence of a valid warrant. And when that objection was sustained, and then the Commonwealth didn't come back and find another way to get that warrant in evidence, they were missing a component of this crime. Isn't that the point?
Agreed, and I don't even believe they were attempting to put in a copy of the warrant. He was just attempting to read what he saw on his MDT. I don't even know if he was looking at NCIC, just his computer terminal.
Right, in other words, saying I heard there was a warrant is not the same as the Commonwealth bringing in the warrant.
Correct.
Which shouldn't be a difficult thing to do.
I wouldn't think so.
Well, but it's go back to the layer thing though, is when you say valid warrant, that's where I'm struggling, is the fact that a warrant is issued and they show that a warrant was issued from a police officer perspective is a valid warrant. Is that enough that the Commonwealth just prove, yes, when the police officer executed the arrest, there was a warrant in place for his arrest, period. Here's the warrant that was in place for his arrest at the time, period. Is that a valid warrant, or are you saying that once the Commonwealth puts that in, they also have to bring the evidence underlying the warrant, to which Justice McCaffrey would say, you know, bring in the clerk of quarter session, bring in the judge, bring in the attorneys that were in the courtroom when it happened, you know, because it's their burden, right? It's the Commonwealth's burden to prove beyond a reasonable doubt that the crime was committed, and therefore prove the validity of the warrant, whatever that means. So what does validity mean?
Validity means that the warrant is supported by probable cause. And I would say, no, we don't have to bring in everyone who was in the courtroom. You know, I mean, the way that we look at warrants and establish whether they're supported by probable cause is by the warrant itself, and possibly an affidavit of probable cause if it's accompanied by one. And in some circumstances, because the judge is there, they see the person didn't show up and they know there was service, there won't be that.
So you're saying, and you said this earlier, four corners. So if they produce the warrant, you were permitted, they don't have to do anything else. They authenticate it, they produce it, here's the warrant, there was a warrant for his arrest, we're done. He pummeled the officer, we rest our case. That's enough. Now you may look at the four corners and say, well, wait a minute, he's not the same Kevin Brobson, there's another Kevin Brobson, it was a different Kevin Brobson, or you might be able to do any number of things, but you can't then say, well, we moved to dismiss because you didn't have the judge testify who issued the bench warrant. You're not arguing for that principle.
I'm not arguing for a specific type of evidence that must come in, but
Is the warrant enough?
in some cases it might be.
Well,
Yeah, I mean, and like I said, I'm not arguing for a specific set of circumstances, because like I said, you know, there's warrants that are issued in all different places, in all different ways, from all different kinds of warrants, from all different locations. I would say that in a lot of circumstances it would be, but what I'm saying is, actually, I'm going to go to the good faith doctrine, and what I was saying before is, both the federal courts and the Pennsylvania courts have agreed that where there is an arrest, and this court held that in Johnson, where there is an arrest on an invalid warrant, that is an unlawful arrest. If the warrant itself is not valid, the arrest is unlawful. And the officer's belief in its validity is sort of besides the point. It's the validity of the warrant that makes the arrest lawful. The only real difference between the federal courts and our courts is when it comes to a motion to suppress, do we put the evidence in anyway on a good faith basis? But it is the lawfulness of the underlying arrest, however they choose to establish that, that makes the arrest lawful. And so we're not asking for this court, and I don't actually believe it's before this court anyway. The only question before this court is, do they have to establish validity of the warrant? And that's what we're asking is, and it has to be something more than the existence of the warrant. It has to be a valid warrant.
Otherwise, it's not a lawful arrest, because we're not, his conduct, Steadly's conduct on the street there, which I watched a couple times, is not enough. You also need the original, the arrest to be valid before his conduct. I mean, right, there has to be a valid warrant.
Right.
That's the point. And I keep coming back to it. And this, we're not, well, let me just stop there, okay.
This really doesn't have anything to do with.
I'm sorry, Your Honor?
This really does not have anything to do with the police officer's conduct.
That's exactly right. It's really just about when an arrest is based on a warrant, they have to establish the validity of it. And there's a number of cases in which they do that without presenting the warrant in the docket and without calling anyone. You know, there's one case, Bolton, I think, where there's an out-of-state troopers receive an NCIC with, you know, a lot of the information from the warrant in it, and it's sort of the issue is about whether they have to have the warrant in hand, and it turns out that because the NCIC report was sufficient to establish that probable cause and to establish everything by just putting that in at trial, that was enough. And there may be a lot of cases where the NCIC has enough information in it that it does support the probable cause determination. So we're not necessarily saying they have to always bring in any one particular thing. It's just that saying, having one statement from someone over police radio saying warrants, it's just not enough. It doesn't even address validity, it only addresses existence.
Okay, I think we understand your argument. Any other questions, Justices? All right, thank you. Let's hear from Attorney Englert.
Good afternoon, Madam Chief Justice and Justices of the Supreme Court. May it please the Court, my name is Alex Englert, and I will be arguing on behalf of the Commonwealth of Pennsylvania, Aplt. This case is about whether the evidence presented at a resisting arrest trial was legally sufficient to allow the trial court to conclude that a lawful arrest had occurred. I want to start by highlighting where we are, which is a sufficiency review. Under that standard of review, reasonable inferences are drawn in favor of the Commonwealth, and the question is not what other hypothetical evidence may have been introduced to further prove guilt or suggest innocence. Rather, the question for the reviewing court is what evidence actually was presented. And our position is that the evidence in this case established that Officer Moore acted with probable cause at the time that he attempted and then actually effectuated an arrest.
Well, we're not, again, I don't know if the focus is on that officer. The focus is, why didn't you bring the warrant when you had the chance to do so at trial all this period of time later? Because what your argument amounts to is, as long as Officer A can say, Officer B told me to make the arrest, that's good enough. It's the same thing.
Well, two things. One, I would say that this is unlike the Queen case, where an officer is just relying on another officer making a bald assertion that that guy looks like a robbery suspect. In this case, you have an officer actually checking a police database himself, realizing the existence of bench
You
warrants.
lost the best evidence objection to that. That's why it amounts to the same thing. Nobody's arguing bad faith. Let's put that aside. As a matter of law, I think it's indistinguishable, because it comes down to, they told me this, therefore, that's the valid warrant. Where's the warrant?
So two things, and I will get to that. Let me first say there was an objection to the officer's testimony about what he did with his MDT. There was also a video from his body-worn camera that was admitted into evidence depicting that exact investigation. The trial court sitting at this bench trial could reasonably infer, based on the combined testimony about what he then confirmed with the dispatcher, that this officer was checking a police database, his MDT, for the existence of the warrants. So I recognize and agree that there was an objection sustained as to his testimony, but there's still evidence as to what the officer was doing in that moment.
Could I ask you a different question? And
Sure.
This is in follow-up to Justice Weck. If Justice Weck's proposal to you is correct, then does that mean that if ultimately what seemed like a reasonable probable cause determination by the police officer and an arrest, if that ultimately turns out to have been erroneous based on something not within the officer's knowledge, like the validity of the warrant was not in fact valid, then does that give rise to our acceptance of individuals resisting arrest and pummeling a police officer just because that person believes that, or may ultimately be correct, that this arrest is ultimately not going to be sustained?
Well, there are other criminal offenses that would cover that kind of conduct, aggravated assault on a law enforcement officer, which was not charged in this case.
Well, there was no pummeling.
Resisting arrest cannot proceed. Yeah. Resisting arrest cannot stand up then.
If in Your Honor's words, and I think that they're important, it later turns out that the warrant's invalid. And that's part of the heart of this issue, is that there's sort of a presumption that because the warrants were not introduced, that they could not have been valid, or that a trial court answering this question of law could not have concluded that. And I think that Justice Mundy, you made an important point earlier, that these are bench warrants that we're talking about. And I think the nature of the warrant is also relevant to this question, because unlike an arrest warrant that's reviewed by a magistrate who's relying on an officer's statements and his investigation, which might include witness statements or beliefs, a bench warrant is issued in a very narrow and specific context. It's issued when someone has had notice to appear in court and has not appeared in court, and it's issued.
It's an order of the court, docketed with the commentary.
Right, and it's issued by a judge and by a judge only for those very specific reasons. So I think, if anything, there's a presumption that a bench warrant is inherently more valid, reliable, supported by probable cause than an arrest warrant.
No, I mean, there's no question the officer believed there was bench warrants. I understand that, and I've seen the video a couple times. The question is, now it's trial time. Where's the warrant? The judge sustained the defense objection, and then you didn't come back and bring the warrant or show the existence of the warrant some other way. So it's not on the officer, it's on you, it's on the Commonwealth for failing to prove a necessary element of this crime.
And as Your Honor pointed out earlier, it's certainly not a hard thing for the Commonwealth to do. Had the bench warrants been presented, I guess we would not be here today. But I think the issue is that the prosecution's decision not to introduce them is that fatal to the conviction. Did it mean that the Commonwealth could not have proven through the evidence that a lawful arrest occurred? I think by analogy, if this had been a suppression motion and there was simply a boilerplate assertion that the arrest was unlawful, but no contention as to the validity of the underlying warrant or that it hadn't been revoked or rescinded or previously served. If the Commonwealth had presented the exact evidence that it did in this case, then a trial court, a suppression court, would not err by finding that there was a lawful arrest.
Let me ask you that. Let me put some meat on that bone a little bit. Let's say a police officer is patrolling and someone runs up to the police car and says, that person across the street just sexually assaulted me. And then the police officer goes over there and effects an arrest based on what that person told them. And that person then that they're effecting the arrest on resists arrest, and the prosecution charges them. Is it enough for the police officer to say, I arrested them because someone told me that they committed a crime? Is that enough to get a conviction for resisting arrest?
I think that in that example, the witness's statement without further investigation might not support probable cause for an arrest, particularly if there aren't corroborating circumstances, if the officer didn't witness.
Well, let's assume the officer believed the individual because of the circumstances. The individual looked like she'd just been beaten up. She seemed to him to be credible, and he had a reasonable belief, okay? Then, could you answer Justice Brobson's question?
In that case, absolutely. Or if it were, say, a domestic incident and a woman ran up disheveled with a bruised eye, cracked lip, there, absolutely, an officer would probably have probable cause of an assault.
And that would be a valid arrest because it was supported by probable cause.
Yes,
so the question is there some, and I actually know there's case law out there to support what your opposing counsel is arguing. I think the United States Supreme Court has issued opinion on stuff on this, so I realize, but it's just, I'm trying to figure out how I can rationalize that answer, which I think everybody agrees would be probable cause to effect a valid arrest.
And therefore, a resisting arrest
And therefore, a
conviction
resisting
would hold
arrest
up.
charge with this idea of a valid warrant and what is required there.
That is exactly my problem.
I'm struggling with that, why we look at the arrest on one hand with all of the totality of the information the police officer has to evaluate the legal validity in the hypothetical I gave you, but, and I think as Justice Wecht points out correctly, the case law when it comes to an arrest based on a warrant seems to say doesn't matter what information the police officer had at the time.
And how can that be?
It's the validity of the warrant that matters.
Well, I do think there's a distinction to be made because in those cases there is a pretrial motion, there's a specific assertion that the underlying warrant was defective. In this case, that didn't happen, and an officer, there's no per se rule that a warrant has to always be introduced at a suppression hearing to prove that it's valid. There's also no requirement that an officer have a warrant in hand to effectuate an arrest or a search.
But you didn't prove at trial the probable cause aspect of that would support the warrant. That's the point. And again, you didn't bring that element to proof at trial. If it's not going to cut it at suppression, it certainly can't cut it at trial.
I would argue that it would under the circumstances of this case, and absent any specific allegation of a basis for unlawfulness, that it did show lawful arrest.
But the burden is not on the defendant. This is a trial. The burden is on the Commonwealth to prove every element beyond a reasonable doubt. Seems like there's a big element missing here.
I absolutely agree that it's our burden and the defendant has no burden. I guess the point I'm trying to make is that absent a specific contention, at least in the suppression context, not a resisting arrest trial, there's no presumption that arrests are pursuant to warrants are invalid, unlike warrantless searches and seizures that are presumptively unreasonable, and then the Commonwealth must, prove their validity. When it comes to an arrest warrant, there's not a presumption that they're invalid. Specifically when we're talking a bench warrant of all warrants.
I'm not suggesting there's some presumption of invalidity.
The problem is you're ignoring the idea that there's a presumption. You're assuming a presumption that it exists.
I think in the context of a bench warrant, it's a fair result for the trial court to have made here.
But how can you say that you're going to you're going to have a conviction of a crime beyond a reasonable doubt when one of the elements of the crime is based on inference, but not proof.
Under sufficiency review, inferences are made.
So then does that disregard the trial judge's ruling on best evidence?
I don't believe so, because there was evidence in the form of the body-worn camera showing that the officer was putting the information that he was given by the defendant into an MDT and discovering the existence of the warrants. He then turns to his partner to ask theft of services, have you seen this charge before?
Well, I've watched the video a couple times and I can't read what's on that MDT. Nobody can read in that video what's on that MDT.
Oh, absolutely, and I'm not suggesting that the trial court could have, but the trial court could reasonably interpret that evidence to be that the officer is putting the information into his police computer and discovering that these warrants exist, especially when you consider the fact that he then went over radio and confirmed with dispatch that they did exist.
Okay, any other questions? Thank you very much.
Thank you, I appreciate your time.
Mr. Minner, would you adjourn court for the day?